Is anybody on the line?
This is Joan.
Okay, good. All right, I wanted to make sure we were connected. Hold on just a moment, we're just getting organized.
Hi, Monica just joined.
Thanks, Monica.
So who do we have?
Joan and Monica right now.
Jackie's going to be on the phone.
She started a new job.
Jackie's here.
Oh, she
Jackie's there.
wasn't quite sure. Dan, if you need water or a snack or something, you've got
Thank you.
plenty of things.
Dan, how are you?
Hey, good. How are you?
Dan, how you doing?
Good. How are you doing?
Good.
It's kind of worrisome, isn't it?
Yep, you're right.
Like I said, some of the lawyers, some of my best friends, but it wasn't my daughter to marry.
That was even worse. I told her that they couldn't become one.
Oh, neither of mine chose to, so.
Well, two of them had thoughts about it, but we are going to join.
It's changed so much.
And I'm not funding for education.
That makes a difference.
Probably got a form, it's 101.
Let's go ahead and call the roll.
Ann Breitbarth,
Here.
Joan Corbin,
Present?
E.J. Giovanetti,
Here.
Barry Lindahl. Here. Joel McCray. Here. Monica McHugh.
Here.
Judith Podorf.
Here.
Jackie Schmilling.
Present.
Can we turn their volume up? I can barely hear. Thank you.
You have 8-0, or 8 members present.
It's not a vote. Let's start with approval of the agenda. Anybody want to make a motion?
Second.
Okay, moved by EJ, seconded by Barry. All in favor of approval of the agenda, signify by saying aye.
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 Any opposed? Aye. Wouldn't that be a bad start for the day? Okay, approval of the September minutes.
Move to approve?
Second?
Moved by Dan, seconded by Barry. All in favor signify by saying aye.
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 Aye. Aye.
Any opposed? Minutes are approved. Public forum. I don't remember the time when anybody used public forum time. Let's move on. Comments from the board chair. A couple of things I wanted to mention. The position that Hannah had, the attorney position, has been posted for a while. And we're still at, what, 0 applicants?
Unless we got any in the last 2 days, but
It's just been posted for 2 weeks,
Yeah.
not a while. But
We had a lot of applications when Hannah was hired. And I assume when the time runs out on this posting, what's that, the 28th? We'll
Yes.
we
just
can extend
repost.
it if we have to.
If you know anybody who you think might be interested coming to the state, you might encourage them to apply. I think there were several that you considered runners-up, and you're going to get a hold of them if you haven't already. But it's been a disappointing response that no one has applied.
I think it's only been active for just over a week, like 10 days now.
Yeah, but still. And you posted the salary range realistically. If we repost, you might not be realistic. What the top is that's authorized.
Yeah, the problem is that when we've done that, then we interview people who then withdraw. We tell them
It's
what's,
better than not getting any.
yeah.
Win somebody over. Margaret had already announced she's going to be retiring the end of March. So I think by next month, we'll start to kind of gear up for a search. I'd like a committee of myself and a couple of other people to kind of have an initial meeting next month and talk about what we're looking for and to help parse through the resumes. I'm thinking, I don't know if the whole board has interviewed people before. I'd like the whole board to interview.
Yeah, and historically, the whole board is interviewed and then make a decision at that same meeting. And we told people that we aren't going into closed session to interview them.
Okay, I hope they have a thick skin when there's a comparative discussion. So if a couple of you would like to help with screening resumes.
I'd be willing to party.
Julie, this is Joan. I have a quick question about the process since Margaret was hired before I started on the board. Historically, does the board itself act as its own search firm?
Yes,
Okay, so that's not outsourced, so it's just committee to begin the process and then interviews with full board?
right.
There's no budget.
Okay, all right, thank you.
EJ, if I get one more, if you want to think it over, either just drop me an email, call, or speak up now.
I would if it doesn't mean another trip to Des Moines, you know,
I don't,
and it almost does. I mean, doesn't it? Just, you're talking about the initial?
I'm
Just-
thinking next meeting, like a committee meeting, we'll meet before the board
Oh,
meeting
okay.
and
I
have an
could do
initial
that.
discussion.
I can do that. Have to be here a little earlier, that's all.
Okay,
Yeah.
all right, I guess we have our subcommittee. And then there may be some additional time involved when we have to sort through resumes. But if we all get us that, we can talk about them by phone too.
Sure.
Okay.
As long as it's not snowing.
Yeah, well,
No
we can talk.
guarantees.
We can talk even if it
No
snows.
guarantees.
And Julie, do you want, because I know the first thing we'll have to do is determine what the job description is going to say. Do you want the job description, the current one, sent out to the three of you?
That'd be
so
helpful.
that you have an opportunity to look at it before the next meeting?
Yeah, we can make changes if we want. So. That's all you get from me today. We have no advisory opinions. That's most unusual. That brings us to cases involving board deliberation or action. Let's start with Kay Bax and the City of Fontanelle.
comments. This is case number 22FC0100. It comes before you as an acceptance order, paybacks, and the city of Fontana. This complaint was filed on September 14th with an allegation that the city violated Iowa Code Chapter 21 by going into a closed session without listing them on the agenda and without a proper notice, and that happened on July 25th. The city provided a copy of the agenda and the minutes for that meeting. The agenda did not list the closed sessions, and the minutes did not indicate the votes of the members present to go into closed session. There were other allegations of Iowa Code Section 21.5 that were also alleged that by accepting, we can continue to sort of review those topics as well. But on its face, with the information we had, it was obvious that 21.5 was not followed.
Do we have either K-Bax or someone from Fontanelle on the phone who wants to speak? Okay, board comments? This seemed fairly clear-cut.
And move to approve the proposed acceptance order.
Second.
Moved by Dan, seconded by Barry. All in favor of the acceptance order signify by saying aye.
Aye.
Aye. Aye.
Any opposed? Boy, we're going to move fast today, I can tell.
Well, I think there's some things.
Our next case is Eric Henley in the Gilbert Community School District.
This is case number 22FC0088. It involves Eric Henley and the complaint from the Gilbert Community School District Board of Directors as a respondent. This was filed on September 2nd, alleging a violation of Iowa Code Chapter 22 on August 5th. He alleged that on August 5th, he sent an email to the Gilbert Community School District records custodian requesting a copy of all documents being reviewed or considered by the board during the board meeting scheduled for August 8th. Later that same day, he alleged that he received that information with a note that she was redacting a portion of the district's food service report to the board because it contained the names of 2 employees who had recently resigned from the food service department. He requested that I obtain an unredacted copy of the report to review for improper redactions, ordered the board to provide an unredacted copy and find anyone found to have been participating in this violation as provided for in Iowa Code Section 22.10. He included a copy of the report with the redaction of paragraph 2 on September 5th. He provided copies of his record request, the board agenda, and the minutes of that August 8th board meeting. We received a response to the complaint on September 7th, and council at that time provided a copy of the unredacted board report at issue, and you can see that as Exhibit 1, that second paragraph, it talks about individuals resigning and have not yet been hired, listed by name. Council explained that the date of his record request on August 5th, the 2 new employees had not been approved by the board and only considered applicants. She added that those names were confidential pursuant to Iowa Code Section 22.7 sub 18, referencing an explanation for allowing the redaction found on the IPIB website. And she did quote one of our FAQs as part of her response. The agenda for that meeting listed personnel, resignation, hirings as an agenda item, but not the specific names of employees. The minutes of this meeting indicate that the board approved the personnel changes as part of the consent agenda and list the names of those individuals who resigned or were hired. So they announced that at the meeting and then put that in the minutes as well. And then there's a copy for you of a link, the IPIB link, website link that she cited. And withholding the release of the names in the report until the board have publicly approved the resignation and hiring of the employees is not a violation of Iowa Code Chapter 22, and therefore recommendation was to dismiss as legally insufficient.
Is Eric Henley on the phone? Anybody from the Gilbert Community School District? Boy. Board member?
The attorneys had a training going on today, so that's, Ms. Weber had said that she would not be able to appear because she was doing a presentation at one point.
Board member discussion, comments, questions?
Move acceptance.
Second.
Okay, Okay, moved by EJ, seconded by Dan. All in favor of the dismissal order signify by saying aye.
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 Any opposed? Well, the next one will take a while. Clark Kaufman and the Polk County Assessor. I had the decision in this case from the Supreme Court included in your agenda materials just so people could review it once more. A little unusual if you counted heads. The majority opinion is written by Waterman, joined by Christensen and Oxley. 3 justices took no part. Mansfield dissented. And let me kind of recap what the issue was on remand to the board. It concerns the names of people who had the search function in the assessor's office disabled. If you've ever used the website, it lets you search by name and pull up the property for property owners in Polk County. But you could request from the assessor that the name search function be disabled so no one could search for you by name. Although I think you could still search by property if you had the address. The records are available in the assessor's office even if the search function is disabled by name, and you can call in and get that information. In the past, the register had requested a list of those people who had the search function by name disabled, and that was printed in the paper. Most recently, Clark Kaufman requested the list from the assessor who had changed position from the previous administration and declined to provide that, relying primarily on Section 22.7.18. And as you know, that's a section that authorizes keeping confidential communications from persons outside of government to the extent that the government body receiving the communication could reasonably believe that those persons would be discouraged from communicating if it were available for public examination. We wound up filing a complaint and had a hearing before an ALJ. The ALJ determined that 22.18 did not apply because, in a nutshell, the assessor couldn't reasonably believe that people would not request the name function be disabled if the list of names were made public, which would mean they would be searchable by name and their addresses could be discovered. The board reached the same conclusion, went to the district court who affirmed, and then it went to the Supreme Court who did not agree. The majority, at least 3 of them, concluded that the assessor could reasonably believe people would not communicate that they wanted the search function disabled by name if their names were going to appear in the paper. And ultimately, the court remanded for consideration of the other half of 22.7.18, who were persons from outside of government. We didn't reach that issue because we had to meet both prongs of 22.7.18, and we found that there was no reasonable belief that people wouldn't communicate if those names were made public. So it's been sent back to the court, by the court to us, for a remand and to determine the other half of the test. Both of the parties are here. Megan Gavin, who represented the assessor from the beginning, and Emily Willits, who would have prosecuted on remand. They were interested in resolving this, and we talked on the phone, we had numerous emails, and after extensive discussion, we've come up with a settlement proposal rather than go through the contested case on remand. You brought copies, Emily? Yeah. Do you want to pass those out? Sure. For people on the phone, we'll pause here and let the staff email the settlement proposal to you. Why don't I do that since you're... And if you guys want to move over and sit here at that table so that we can hear on the recording of it. The proposal isn't terribly long. I'll give you time to read it, but let me just kind of recap what we're recommending and why. Ultimately, we're recommending to the board that the matter be dismissed. we not pursue another contested case on the second prong of that test. And there are several reasons why. The first few paragraphs summarize factually and legally what's happened to this date. And starting in paragraph 10, we highlight that during the pendency of this action, there have been legislative changes that impact what names are public. I guess I should preface it by saying there are a couple of possible answers to who are people outside of government. I think there's some evidence in the record testimony that outside of government means outside the assessor's office. And that would be virtually everybody, but a couple of people in the assessor office who had their name search function disabled. I think the more sound legal view is that outside government means outside of government, that the communication comes from people in the private sector whose communications would not be public but for the fact that they're communicating with a governmental body subject to Chapter 22. After the case had been filed, I think the contested cases had been held, the legislature enacted new legislation that impacts this. If in fact outside government means in the private sector, then it would not cover judges, policemen, county attorney's office, people like that who have an acute interest in not having people locate them and know their home address. Now, by a separate statute, the law provides that on request by a peace officer, civilian employee of a law enforcement agency, state or federal judicial officer, state or federal prosecutor, the county assessor, county recorder staff shall redact the requester's name contained in electronic documents that are displayed for public access through the internet site, which means by statute, you can't search by name for those people in the future, regardless of what the resolution is under 22-718. In addition, for people who are former public employees who would fit within those categories, if there's evidence of a compelling safety issue, their names will be redacted as well. Another statute that impacts this has been enacted as 9E to protect certain individuals who are attempting to escape from actual or threatened domestic abuse, sexual abuse, stalking, assault, or human trafficking, and who establish new addresses that they do not want to be discovered, and their identity should not be revealed through a public record search of their property records. Those impact the outcome insofar as if we have a contested case and determine that the second prong means people outside of government, the names will remain confidential anyway, pursuant to statute. Similarly, people who are victims, as delineated, their names are going to not be discoverable regardless of the outcome under 22-718. There are certain practical problems with trying to conduct a hearing and deciding how 22-718 applies. Megan tells me they could search county records against the original list formulated in 2017 and discover who county employees are, but we wouldn't necessarily be able to discover who federal, state, city employees are, who are now confidential by a separate statute in any event. The names of people who may be victims and may have asked for their names to be redacted from the search function because they're avoiding a domestic assault or human trafficking, or they have some history, they don't want to have their residences discovered. Their names were never collected in 2017, I'm fairly certain, with any indication that that's the category they fit into, so they wouldn't be identifiable. We would have trouble complying with the second statute for that reason. You're simply not going to know who on the list fits within that category. The other fact we put in the settlement agreement, and Megan pointed this out to me, there is an article in the Iowa Capital Dispatch, which the requester, Clark Hoffman, writes for, stating that he has the list. That was not authorized by the assessor's office, and the source of that information is not revealed in the article. So between the fact that he already has the list and that other statutes are going to impact the confidentiality and it would be very difficult to discern in a remand hearing who exactly fits in those categories. We're recommending that we dismiss the case. I think people on the phone, Margaret has emailed you a copy of the settlement so you can open your email and have a look. And let me give people a few minutes to read through it. We'll see if there are any questions.
And if anybody didn't get it, let me know, but I sent it both to their iowa.gov and also to the other email address I have for them.
Okay. Did people on the phone hear that? Margaret sent it both to your state email account and personal account.
Yes. Right. Joan, I got it.
It says that it's included in the packet.
No, we did not include it in the packet. If it's approved, we'll sign it and then copies will be
It has
available.
asterisks on it.
That was because we included the Supreme Court decision.
Just asking.
Yeah, that was the attachment that was included.
Looking around the room, I think a lot of people were not here when this case started.
Julie, here's my question. This is Monica. Yes, I remember this case. We have obviously the court hearing, but can we vote on this settlement at this meeting?
Yes,
Okay, that's what I wasn't sure about.
it's been remanded by the Supreme Court back to the board.
Okay. I guess I would agree with the settlement agreement with dismissing the case because of the changes in the Iowa law. And I know this was a difficult one for the board as well.
I think it's really the soundest resolution. It's kind of just, let's put an end to this. It would leave the assessor's office to kind of sort out how they're going to collect those names in the future to comply with the statutes. Other discussion, questions?
So essentially, we're saying that it's now moot because of the new legislation. I mean, that's the,
You know, I don't think it's actually moved because it wouldn't change whether there was a violation back in time when the incident occurred, but I think it's not resolvable.
going forward, it's
Yeah. Other provisions of law are going to affect the confidentiality, which we're not going to be able to sort out in a contested case.
well, I would support the settlement.
I support it as well. I don't know if there's any other dissenting opinions, otherwise I'm willing to call to a vote at this time. I guess I'll just make a motion to approve the settlement.
Well, any other questions from people on the phone? EJ?
No, I've abstained throughout. I think it's
I'd forgotten that. I'm
I
sorry.
would continue to abstain.
Joel? Your motion?
Yep, move to approve the proposed settlement.
Second.
Moved by Dan, seconded by Barry. All in favor of the dismissal order signify by saying aye.
Aye.
Aye. Aye.
And I abstain.
EJ abstains.
Seven votes in favor.
Yeah.
We do need a follow-up vote on the underlying complaint, which was Clark Hoffman. versus the Polk County Assessor, that's 17 FC 0029. And we felt that open, heavy resolution of this.
This provides for dismissal.
So that would include the underlying case, even though it's not listed here.
It's
No,
not
it is
listed,
there.
but-
It is there. Okay,
It's on the caption.
yeah,
Okay.
okay.
Okay. Okay, why don't we use my copy? Megan and I need to sign it, and then we're done.
I just have a practical question. How does the assessor redact electronic records on the internet?
I can let Megan answer, but I think what he does is disable the search function. So if you put the
Oh.
person's name in, you're not going to get a result.
It's twofold. The legislation goes farther than the assessor's previous policy. The previous policy was you could search by typing in the name, but if you had the address, you looked up by block, it would pull up the full property record, which would include the name. Now, however, we're not able to include the name at all. I believe currently, and I might be wrong about this, the name is simply left blank on all areas, although that's potentially problematic too, because then it reveals somebody who wants their name not to be searched. So this is a little bit complicated in the execution of it. But basically, we have to have a specialized electronic input set for people that fall into this category.
Yeah, I think another thing about the legislation was, so prior to this legislation, Polk County had this practice of allowing people to request their names to be redacted. There were some other counties around the state, I'm not sure which ones. Now every county statewide has to offer that option for people to request their names to be confidential if they want to.
And
One of these categories, right?
yes, and functionally, people didn't have to go off for a reason. A lot of people just didn't merely offer a reason on why they wanted to, but now the law requires the assessor's office to determine if they fall into one of these categories, and then certain of them require some specific security concerns, or at least express that. It's kind of ambiguous what that means, but at least it requires something on behalf of the requester.
Thank you.
Margaret's gone to make copies. So let's take a little pause until Margaret gets back. I don't know about the other board members, but I'm sure Megan and I and Emily are happy to have this case resolved.
I inherited this case from someone who's now been retired for 3 years,
Who was that?
Dave.
Is he the person who came to a couple of board meetings?
He did. And his lack of, I love Dave, but his lack of technology and being able to answer the questions created some confusion in the early stages.
I think that's true.
And he wasn't about to change.
No, it was a well-intentioned ignorance on the computer system.
But yeah, I think he appeared twice and we didn't get anywhere.
Do we need a motion to notify all previous board members?
No, no. I don't think there was a reason given why 3 of the justices didn't participate. I assume they have property and their names have been disabled.
That's what I assumed too. I was very surprised that day at the oral argument when both of us went up to approach our respective spots. Only 4 justices came out.
Yeah, I was waiting right after the chief and then Justice Appleton come out, and I was excited. It was my last opportunity to argue before his retirement, and then he was not there.
Megan clerked for Justice Apple. But his home is not in Polk County.
It's not, but I do remember this particular, having clerked during Varnum, I do remember this particular issue coming up during the pendency of that case amongst the justices. So that would be my guess as to why personally asked him as to the other justices, I don't know.
Came up in Varnum because people were concerned about having their home addresses discovered.
Because of the constant deluge of death threats at the time.
Yeah.
And I think it was a recommendation of perhaps of public safety at the time as well.
Well, I don't know what the impetus was behind this most recent legislation, but there have been bills like this all around the country, and there was federal legislation in the wake of that really awful shooting up federal judge in New Jersey. So there's been a push, I think, by judges and prosecutors' offices around the country to try to get more protections.
Well,
For
that
addresses.
being the goal, I think it's odd that it's limited for the judges to internet searches, because people can walk in the courthouse and find out where everybody lives, or phone. So if they were concerned about safety, I think they would have taken a broader approach.
Well, what we didn't do is get a list of other people on the phone.
You know, I
If we
didn't.
want to do that,
No,
while we
I
wait.
don't. I'll just ask
Okay.
by cases as they
All right,
come
we'll
up.
get it. That's it. All right.
It's half the time I can't hear who they are. I don't remember who they were, so we'll just give people an opportunity as we come to their cases. Thank you, Margaret. The original's on top. And then make sure Emily and Megan get a copy. I think so. Maybe she can, when it goes to the court.
Well, this has been remanded from the district court to the board. Let me look at that. I don't know that we
Need to go back.
need to go back, but I will look at that, and if something does need to be done.
Yeah.
What's your feeling?
Dawn, I have an unsigned
I
one.
assume, I would say, yeah, flag with the email.
It couldn't hurt. It kind of skipped through the district court to us, so,
We get orders from the court,
yeah, remanding.
I would think. I suggest we send it, please file it.
I'm sure the district court judge will be interested.
And
I mean, since it's still open, way to get rid of it, get it closed, yeah. I think it was Jeff Farrell, wasn't that the district court judge in this case?
Yeah, I think it was.
Which district court?
Was it Judge Farrell?
It was, and the reason I have a distinct memory of this is we
Yeah.
had to do the oral argument by phone. It was during the early days of the pandemic, and I was walking my daughter back and forth to my house to keep her quiet.
I remember that.
She's now 3.5.
This case has been hanging for a long time.
Yes, thank you all.
That was like the other one.
Thanks, guys. They were patient as I would sleep on it and dribble out edits over numerous days. Did you get a copy, Susan?
Yes, I get it. And there's extras in case somebody else wants one.
Okay. All right, I'm glad to put this one to rest. Our next case, Matt Lawfer in the city of Marengo.
Excuse me, yes, this is case number 22FC0097, Matt Lawford, and the city of Marengo as the respondent. It comes before you as a dismissal order. It was filed on September 18th, alleging a violation of Iowa Code Chapter 22 on August 12th. Mr. Leffler alleged that he made a public records request on June 26th concerning citations issued between January 1st, 2021 and June 26th, 2022 for violations of a municipal law concerning animals. He received a response on July 11th, 2022 stating that the records were ready to be picked up and estimating a fee of $45 for the copy. He stated that after he received that information on August 2nd, he then submitted a revised record request and attempted to make payment for the estimated fees of $45. Staff asked him to return on August 4th to make the payment, as the city clerk was not available to accept the funds at that time. On August 4th, the city clerk told him he did not need to pay for the records until they were retrieved and copied. Then on August 12th, he received an email that the records were ready for him to pick up and that the actual final fee for the records was $11.75. On that day, he stated he received 7 pages of records, and he questioned both the time it took to receive the records and the fee schedule used by the city. He also had other questions about the contract the city used to obtain animal control services and whether the city was unfairly targeting him in enforcing municipal law. Those matters were not within the IPIB jurisdiction. Legal counsel, IPIB informed the city of the formal complaint on September 30th. On October 10th, the city attorney responded to the complaint. In response, the attorney stated that the initial estimate was not charged to Mr. Hopper as the attorney had the records readily available, so that's why the cost went down. He also noted that that Mr. Hopper did not respond to the July 11th communication from the city until August 2nd, and at that time the records were prepared and then ready for release on August 12th. He picked up the records actually on August 16th, and he informed us the trial of his citation was held on September 6th. The amount of time between the revised record request on August 2nd and the notification that the records were ready for him on August 12th is not an unreasonable delay pursuant to Iowa Code Chapter 22. And also Iowa Code Chapter 22.3 allows a governmental body to charge a reasonable fee based upon the actual cost of retrieval, review, and release of public records. On its face, this fee does not appear unreasonable. The city has a fee policy that was approved in April 2021. I did speak with the city and asked that they look at that fee schedule for possible revision based upon the modifications to Iowa Code Section 22.3 that became effective on July 1st of 2022. My recommendation is we dismiss as legally insufficient. And Mr. Lawford did file a response, a written response. I'm not sure if he's going to be on the phone, but that was included in the board packet and is attached to the meeting materials.
Well, we'll find out. Mr. Lotfer, are you on the phone, and do you care to speak to the board?
Yes, I'm here.
Okay. You have 5 minutes if you'd like to address the board.
Okay, everything I think I have to say has already been included in that final email. My concern was the amount of time it took for them to respond to the first record request, and then to respond with it with a $45 charge or a $45 bill that wasn't what I had requested. What I'd asked for was information in the city's code of ordinances, and it feels like at least they were using that opportunity to charge an unreasonable amount. The city attorney didn't need to be involved, and that's what they based that fee on was city attorney's time.
But the fee did get reduced.
Yes, it did, because I removed that from my request. It wasn't because the records were readily available, like Mr. Kentler said. It was because when I made that revised record request, I took that out of there.
Anything further?
No, I don't believe so. Thank you.
Is anyone here from the city of Marengo? Nope. Board comments or questions about the case?
The $45 was just an estimate, right, before they even looked for the document, so.
That's
Doesn't mean
correct.
they would have charged him $45.
That's correct.
Do we know from their schedule of fees how they arrived at the $11.75?
It was just on copies.
Just copy fee?
Because there was an underlying litigation that the city attorney was doing, the records didn't need to be searched. They had that information.
I mean, I feel Mr. Leffler's pain if he requested certain policies or documents and he was given the wrong information. But I don't necessarily know that it's our job to make sure the city of Marengo provides the proper documentation. I think that's between him and the city.
It got corrected.
And it got corrected, right? That's what yeah, I think the $11 is fair. I don't know if anyone has a dissenting opinion. Motion to approve the proposed dismissal order.
Second.
Moved by Dan, seconded by Barry. All in favor of the dismissal order signify by saying aye.
Aye. Aye.
Aye.
Aye.
Any opposed? Our next case is Michael Merritt and the City of Newton.
Yes, this is case number 22FC0071. It's Michael Merritt in the City of Newton. This comes before you as an informal resolution report. This case was filed on July 20th, alleging a violation of Chapter 22. The complaint was accepted on September 15th, and the parties have agreed to an informal resolution as outlined on page 2 of the report. My request is that the board approve this and allow the chair to sign the informal resolution, and then we'll go forward with doing everything that we've got listed in it.
Do we have comments from Mr. Merritt or legal counsel for Newton? Matt Brick? Nope. Questions or comments from the board?
I move approval of the informal resolution report.
Second.
Moved by EJ, seconded by Joel. Then we will approve this and set the matter for compliance review in 90 days.
Yeah.
All in favor of the informal resolution signify by saying aye.
Aye. Aye.
Aye.
Aye. Aye.
Any opposed? Next one is Michael Merritt
Yes,
and
this-
Jasper County.
No, I think this one's City of Ames.
Oh, I skipped him. There's more Merritt.
This is case number 21FC0090. It's Michael Merritt in the City of Ames. It's before you as a dismissal order. This was filed on September 6th, alleging that the city violated Iowa Code Chapter 22. He alleged multiple complaints. He said that on April 15th, he requested records from the city. He was told the records were confidential pursuant to Iowa Code Section 22.7 sub 5 as peace officer investigative reports on April 29th, 2022. On May 11th, he received an acknowledgement from the city that they received a payment of $168.21 fees associated with a different record request. He stated that on May 27th, that the city responded that there were no records responsive to his request. That one apparently was an earlier one, and he did not end up having to pay any fees because he didn't have any records. Legal counsel for the, and that should be for the city, I'm sorry. I will make that correction. Legal counsel for the city responded telephonically to the complaint on September 8th, stating that the IPIB did not have jurisdiction over either complaint pursuant to Iowa Code Section 23.71. That states that complaints before the IPIB must be filed within 60 days from the time the alleged violation occurred, or the complainant could have become aware of the violation with reasonable diligence. This is a jurisdictional requirement, and the alleged violations that occurred on April 29th and May 27th both exceed that 60-day filing requirement. And also, 23.8 sub B states that the IPIB shall decline to accept a complaint that relates to a specific incident that has previously been disposed of on its merits by the board or a court. We did dismiss 22FC0020, which is the complaint that is involved in this record request number 2, and that's so. And also, that's more than 60 days since the filing of this complaint. So, it's the the recommendation is that this be dismissed as beyond the jurisdiction of the IPIB.
Mr. Merritt was not on the phone before. Is Mark Lambert on the phone?
Yes, I am.
Would you like to address the board, Mark?
Just very briefly, I did talk to Ms. Johnson on the phone. I apologize for not getting a written response to this. I've been short-staffed, and I had to take a week off because my daughter was getting married, and I was helping with that. So I was actually working on a written response when the proposed dismissal order came. So at that point, it seemed pointless. I just would say that I'm in agreement that, with the proposed order, that both of the issues mentioned in Mr. Merritt's complaint are well past the deadlines in the Iowa Code, and that this should be dismissed. I do want to add, too, that Mr. Merritt's request is an extensive email search request with lots of terms, and the quote was mostly for the IT department, and then some for me to review, looking for anything confidential. There was nothing responsive to his request in that, and we let him know that. We also refunded about $10 to him, a little under $10, for because he'd wanted the results on a flash drive sent by priority mail, and so he, since there were no results to the search, we refunded that $9 or $10 to him which is way less. I didn't know priority mail had gone up so much, but we had we refunded that so that because we didn't need the flash drive or the priority mail, so we gave him that money back.
Thank you.
That's all.
Board questions or comments?
Second.
Moved by EJ, seconded by Dan. All in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Sorry.
Aye.
Wait for the ayes. Anybody opposed? Dismissal order is approved. The next case is, again, Michael Merritt, Jasper County.
Yes, this one is 22 FC 0091. It's concerning Mr. Merritt and Jasper County as respondent. This was a rather lengthy, it was a 10-page complaint document alleging numerous violations by the county. The only issue that appeared to be a Chapter 22 allegation concerns the request he alleged he sent on August 17, 2022 for public records regarding the list of citizens blocked from social media assets managed by Jasper County, Iowa during the 2022 election year. He added that on August 18th, the county sheriff responded that he could not fulfill the request as I do not have access to that information. So he got back from the county sheriff. He then followed up with an email to the county attorney on August 29th, which had not been answered by the time he filed the complaint on September 7th. Jasper County attorney had contacted the IPIB on September 16th and filed a response on September 22nd. In response to the complaint, the county attorney stated that the county has no such list as does not exist anywhere. There's no public record of such a list kept anywhere in Jasper County, including in its computer system. Because such a list does not exist, it was impossible to comply with Mr. Merritt's request. He's basically asking for the creation of a record that they didn't have, and therefore they could not provide that information for him. Public records are defined in Iowa Code as records stored or preserved in any medium of or belonging to any county. If the government body does not store or preserve a specific record, then there's no record to be released to a record requester. My recommendation is that we dismiss as legally insufficient, and you will note that there is a 4-page response to that order that has been included in the packet.
And I assume, again, Mr. Merritt's not on the phone. He hasn't been for the other two. Is somebody...
He had said he was going to stand by for this one, so I'm not sure.
Are you there, Mr. Merritt? Do you care to speak? Yes, not. And do we have anybody there here from Jasper County who wishes to talk? Board member questions or comments? Well, we were just whipping right through these.
My guess is that Mr. Merritt got blocked by someone on Jasper County, and that's why he's upset. I mean, I think the attorney for the county put it pretty succinctly. There's no list, so I'd move to approve the dismissal order.
It is my understanding, and both parties said that he was not allowed to make comments on their Facebook page.
Can I ask a question? You can say no.
I don't care.
I get that there's no record because there's no thing, but if the government has a Facebook page, they own that Facebook page, they could go into that Facebook page and see who they blocked, and that would be a record. I mean, that's a record. Just because they may not know that they can do that, doesn't mean
That may
it's
be
not
the
a record.
problem.
See, I don't actually know that you can look at the individuals you blocked. I don't know if that's actually possible. Because I was just looking at the Jasper County Facebook. I mean, even if I just went to my profile, I don't even know if it's possible to look at the individuals that I blocked.
Are there many?
No, I don't know if I have or not. That's the thing.
Well, yeah, because you can go on there, I know, and block ads. I
No,
know.
this is different. You're blocking individual people.
No, but I mean, you can't block certain ads too.
No, I know, yeah, I understand. I'm just not sure if we know whether that is or is not a record. That's all
Yeah.
I'm stating.
And I know like the IPID Facebook page, which I'm a proud observer or monitor on and whatever. When I set it up, I just put, nobody can make comments. So all comments are blocked, but I won't know who tried to make comments and wasn't able to because they don't notify me of any of that kind of stuff. It's just an overall no comments.
Well, given Susan's observations, are we willing to let it go as he doesn't think there's a record?
I'm just making a comment that I'm not sure whether we know the answer or not yet. And I would be happy to find someone who can figure that out, who knows more about Facebook administration.
Right. I think historically, this board has said that we don't require a government body to go and make a list if they don't have that list already available. I mean, even in the Ripper case, the county there acknowledged that they did have a list. I mean, and so otherwise, I'm not sure it would have even gotten as far as it did because they did actually have a list that they could disclose, but they were cited as confidential. So, I mean, historically, we told people they don't have to make up a record to respond to a record request if it's not within their possession or stored or preserved as required by Iowa code.
I think we should find out whether or not here's, I think you do know. I think you don't automatically do it if you go in and do it, don't you? I mean, I don't know.
Yeah, I have a list of the people I blocked.
Do you want to take?
You do? I do. You have a list? Yeah, if you go through and you're blocking your audience and visibility section, there is a blocking,
All you have to do is hit print,
and yeah,
screen
Okay.
grab.
it's there.
Joe Betty, right?
Well, do we want to table this and let Margaret look into?
I could certainly explain to Jasper County that there's a consensus that there is a way that you do have a list.
I think at least they have an obligation to find out for themselves. But, yeah, I guess for the sake of transparency,
Had Dan already moved to?
I'll withdraw my motion.
I'm sorry.
Okay.
Yeah, I'll withdraw my motion.
If you're moving to table, do we have a second on the motion to table?
Second.
Okay, moved by EJ, seconded by Joel. All in favor of tabling, signify by saying aye.
Aye.
Aye. Aye.
Any opposed? What?
No, I just have a question.
Sure.
So, there's a question about who has the responsibility to follow up with Jasper County. If they say, we don't have a list, do we tell them,
I will.
prove it to us, or is that the?
I'll go back and I'll just tell them that,
They can screenshot They could screenshot that.
Yeah.
Send it back to us as empty.
Well, and to him too,
Or,
yeah.
They may just not be aware.
Yeah.
And
Lack of knowledge of the laws.
But if it's there, the fact that they don't currently have a copy in front of them doesn't mean there's no record. There's one electronically. So we'll let Margaret.
I mean, Mr. Barrett did provide in his response an outline of how to do it, so. So, no problem.
Our next case is Peasley Courtney and the City of Derby.
This concerns a final report from the complaint filed by Courtney Peasley and involving the City of Derby. This complaint was filed in April. It was accepted on July 21st, and there was an informal resolution that was approved by the IPIB on July 21st, and the terms were completed. At that time, we were supposed to be completing no later than September 19th. However, there was a continuance granted by the IPIB in September to allow them to go to September 30th because they couldn't get the training scheduled that they need. That has been completed, and the recommendation is to dismiss this case as resolved through informal resolution.
I assume that Courtney Peasley or the City of Derby have nothing to add since it's been completed. So all we really need from the board is a motion to dismiss the complaint as successfully resolved.
So moved.
Second?
Moved by Joel, seconded by, is that Dan or?
Yes.
Yeah, by Dan. All in favor of dismissal in response to the final report, signify by saying aye.
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 Any opposed? The matter is dismissed as successfully resolved.
What's
No,
that?
I heard three ayes.
Yeah, I am.
Okay, this next case is case number 22 FC 0050 involving Mary Radke and the City of Palmina. This complaint was filed on May 26th, and the allegations of the order and ruling is listed there. It was accepted on August 18th, and the parties have agreed upon the following terms for an informal resolution. That's all listed there for you. There's 90 days. The terms will be completed within 90 days of the date of approval by the this informal resolution by all parties, and can be then dismissed, successfully resolved after 90 days of completed. It was approved by Ms. Radke on September 8th and by the City of Paulina on September 15th. It's my recommendation that the board approve the informal resolution and direct the chair to sign that.
And set the matter for compliance review in 90 days?
Well, you don't need to. I'll monitor that and then make sure that it comes back, that it's completed.
Do we have a motion on the informal resolution of this matter?
So moved.
Second?
Okay, moved by Barry, I think seconded by EJ. All in favor signify by saying aye.
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 Aye. Aye.
Matter's approved. That brings us to another Mary Radke and the City of Paulina. The dismissal order.
And I would note, too, that Ms. Radke had filed a response to this, and this was filed last week on the 14th, and in that response, she asked that the case be withdrawn. So before going further with it,
Okay.
it's up to, we'd already, at that point in time, set the agenda and sent board materials out, so that's, at this point in time, the board's decision as to whether or not they have any objections to withdrawal.
I think we should let her withdraw it. That's what she wants to do.
No objection?
Do we need a vote on the withdrawal? Agree?
The only thing I would say is perhaps have a vote to allow withdrawal.
To accept the.
Yeah, to accept that.
Yeah, I would move to
permit the withdrawal of the complaint.
Second?
Moved by Joel, seconded by Barry. All in favor signify by saying aye.
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 Aye. Aye.
Any opposed? Motion passes. Goodness, that brings us to the last item on our action agenda. Kate Zimmerman and Ringgold County.
Yes, this is case number 22FC0086, Kate Zimmerman and Ringgold County as the respondent. It was filed on August 23rd, alleging violation of Iowa Code Chapters 21 and 22. Her allegation was that the Board of Supervisors attended a special meeting held by the City of Mount Air on August 3rd that created a quorum without the Ringgold County auditor present, as proven by official City Hall minutes published on August 11th in the Mount Air Record News. It was also confirmed on August 22nd in a supervisor meeting that the auditor was not present during that August 3rd meeting at Mount Air City Hall. There was no information alleged to provide any violation of Chapter 22 Public Records Law. Ringgold County attorney responded to the complaint, acknowledged that 2 of the 3 supervisors were present at the meeting. He added that while the 2 supervisors were present, their attendance did not constitute a meeting. He said the attendance was ministerial in nature. The City of Mount Air is considering construction of a new swimming pool. The agenda and the minutes for the City Council meeting indicated that the purpose of the meeting was informational only. And the City Financial Advisor was providing information to the audience there about potential funding, and the 2 supervisors were attending in order to get that information so that they could then at a later time discuss that at an open meeting with the Board of Supervisors. And that was all confirmed in the minutes and newspaper publication provided by Ms. Zimmerman. Based on an analysis of the law and the facts of the situation, it appears that the attendance of the City Council meeting was ministerial to gather information on the city pool project. I did note in discussing this with the county attorney that best practice might have been for the city to post a notice that they were going to be attending that City Council meeting, and to avoid even the suggestion of an informal, improper meeting, which a lot of counties will do that. There were no allegations as to Iowa Code Chapter 22. Also, Iowa Code Chapter 21 does not require the county auditor to attend meetings of the county board of supervisors. So my recommendation is this is legally insufficient.
I guess I was confused reading the order. There was an agenda and there were minutes.
But it was a City Hall agenda minutes, because it was a city council meeting that they went to hear information about their pool project. Apparently, the county had the ability, and they were going to then discuss at a later time whether or not they were going to provide some funding, county funding, to the city on that.
Well, is his complaint, or her complaint, anything other than the auditor wasn't there?
That the auditor wasn't there, and that it was a quorum. They were attending it as a meeting, so therefore they should have been there. The auditor should have been there because it was a meeting.
But she doesn't allege any deliberation?
No.
Didn't we have another case like this not too long ago where we decided
Yes.
on very similar facts that it was deliberation?
We had one where we decided that it was harmless error. That was the one with Fremont County last month that I didn't participate in. But that was where 2 supervisors were, after a meeting, were contacted the attorney for the wind turbine project, and the board dismissed that as harmless error.
What do you think about the Bettendorf case? The Bettendorf School Board here.
Well, they went out
Had a
to
bunch of them, yeah.
they went out to a building site and were,
We had
Yeah,
that one
that
as
was a
well.
couple, that was a year and a half ago, yeah.
yeah. But didn't we decide that was deliberation?
Well, that was the one,
would say
that was at
Dare.
Dare County when they did the walkthrough.
Yeah, that one.
With the inspector, and gave the
Yeah.
inspector direction on how to go about what they were going to do. They decided what they were going to do about the inspector's discussion. I mean, so they were deliberating. They were actually having a conversation. And deciding what they were going to do. In this case, they were attending because they wanted to hear the presentation.
Well, I have problems calling it ministerial. I think we've made the word ministerial a lot bigger than it really is. You cite the AG's opinions, and I dug them out and read through them. Both the last two, Stork to Rice and Stork to Rocane, were written by the same person less than 6 months apart. But the one that's really on point is the one I've raised before, Stork to Rice, when she was the director of the Civil Rights Commission. And it concluded that if you're going to the prison to listen to prisoners' concerns, civil rights concerns, that's deliberation, even though you're just hearing their concerns. Certainly to try to hack deliberation up into steps and fact gathering isn't part of deliberation, only actual discussion, I think is artificial. I'd rather call this harmless error instead of ministerial. It was posted then apparently by the city.
Yeah.
So it wasn't like a meeting that was held without any notice to anybody. Probably they should have posted it separately.
Well, but I know, like, when I was county attorney, our supervisors posted where they were going to be all week. So whether there was one or two of them, if they were going to attend some other group's meeting, that would be posted at the courthouse. So
That might be overkill. I would just rather we disposed of it by calling it harmless than ministerial, because I don't think it's ministerial.
Julie, this is Joan. I would comment on that as well. I would agree with you. I see ministerial as not really relevant with this. I think that's used in other kinds of things when you're needing just like a date for something, or, needing to poll to see if people can attend something or something like that. But I also would say that the commentary that Margaret, I believe, put that it would have been best practice to post the supervisors, because I think it's clear that, or it seems clear that attendance was for informational purposes.
I just think we're stretching ministerial farther than it's meant to go.
I understand what you're saying. I have a problem with calling it error.
I mean, for the oversight of if they should have posted something, if a majority of them wanted to be there, but it was posted anyway in the city.
Do we have minutes? Get minutes from this?
The city had minutes.
Is there any of the city minutes that show that the two supervisors participated all and just sit there and listen?
there wasn't anything in the minutes outside of just that this guy was doing the presentation to provide information. And said, as part of the minutes, it did say that he indicated that he was going to be presenting information to the board of supervisors at their meeting, which was going to be the next week. So there wasn't any discussion or anything at all. They just, I think they kind of crashed the meeting. There's no meeting, they can go. But it would have been wiser just to send one, you know?
Oh, yeah, well, I have no question about that. I understand Julie's trying to define ministerial, which I don't necessarily agree with, but I think to call it any kind of error, I don't know, I'm comfortable with that, I guess. Maybe.
I'm more comfortable with that than calling it ministerial.
Yeah.
The opinion that Margaret quotes from isn't really, that's not the question posed, whether just fact gathering. There's discussion that sounds like it supports it, but that's not what the opinion's about. The Rice opinion is exactly about that. The Civil Rights Commission goes to listen to people. Apparently that's all that occurred, but they conclude that it's part of deliberation to just fact gather. It matters within the scope of your policy-making duties. And it makes sense to me that the public be on notice and have a chance to see the fact gathering. That's half of the decision-making process. So I support dismissing it, but I don't like the rationale. And I think that comes back to harmless.
So section 21.2, subsection 2, in the definition of meeting, I'm sort of keying in on the last sentence where it says, when that a meeting is not when there is no discussion of policy or intent to avoid the purposes of this chapter. So do we believe that by having a presenter present facts about a potential pool project, do we believe that is discussion of policy, or do we believe that the city was trying to avoid open records law? Because I don't necessarily know that I do. I don't think that simply giving information is a discussion of policy, whereas listening to the public complain about potential policies that are affecting them obviously is more in line with that. But I think purely giving facts about, you know, a potential pool project isn't necessarily a discussion of policy. And to me, it doesn't seem like they were intending to avoid the purposes of the chapter because they published it, right? So I think this isn't within 21.22.
Because it's not
It's
a
not the
meeting.
city, it's the county.
Right.
The city didn't do the most.
Yeah, the
Okay.
Well, I
I
think
think we just,
city has a meeting, but not the county.
the county.
There's no
County's the
meeting.
question. The city didn't have it.
well, then what was the county there for? And they have some
They
function.
listened, you listened because they were going to present to the county the following week. Typically, they're seeking funds from the city of Mount Air and also seeking funds from the county of Ringgold.
Then why aren't
But
they
they were
fact?
there to listen to the presentation so that they presumably could be prepared for when they come to the county asking for money.
Well, to me, then they're gathering facts that are relevant to their decision making. I think it's just a misunderstanding of ministerial to call that ministerial. You think of ministerial, as Joan pointed out, it's like if you're signing orders or it's cleanup type work, it's not having to do with policy making. Taking in facts that relate to policy making, to me, is not ministerial.
I'm wondering, because another thing that comes up a lot that we historically said is ministerial is when they go to trainings. Like the Board of Supervisors goes to.
That's not ministerial. It might not be a meeting, but it's not ministerial.
So that needs to be noticed then when they go to trainings.
They're simply receiving training on the way in which they carry out their job, but they're not gathering facts that they're ultimately going to make some decision about. All right. Are Joan and I the only ones bothered by this? I don't want the precedent of an order out there calling it ministerial when you're gathering facts.
Is there another word that we could all agree on?
Well, I don't think we're all going to agree. I'd rather see it called harmless that they failed to post a notice.
Well, I don't know where we are in deliberation. I mean, I don't think fact gather, purely listening to a fact presentation is deliberation.
I agree.
I mean,
It's what the AG opinion says it is. And they go to...
well, that's the AG's opinion, right? Yeah. You know, that's 21.22. The first sentence says it's a meeting where there is deliberation or action. The second sentence just gives you an example of things that are not meetings. It's not exclusive. I mean, just because something is not ministerial doesn't make it a meeting. You know, that's just one example of something that's not a meeting.
Yeah, so that's why I agree, it's not a meeting.
I don't think it is either.
Yeah, so therefore it can't be a violation
Yeah.
because there was no meeting.
You don't have to get to the ministerial issue.
I think that's where I was getting at as well. They attended as members of an elected body of the county, attended a meeting held by the city, potentially as bystanders just to hear. I don't see.
Yeah, there's no allegation that they participated, there's no
No.
allegation there was any deliberation. They were there to listen, therefore to me it's not a meeting and there's no violation.
Do you want, if you want to, I could retract this and just focus on the deliberation aspect and not talk about ministerial at all.
I'd be happier if you didn't talk about ministerial at all.
I mean, that's something I do, but I would need to have a table so I could get that drafted.
And I'd be happy to look at it while you work on it.
If it was proposed as a dismissal order because no meeting was held, I would motion to approve it.
Would
Need to
still
be
be legally
redrafted.
insufficient, it just would be legally insufficient on a
Right.
different
Yeah.
basis.
So why don't we
Yeah, that's
table
what
it
I'm
and bring it back?
Okay.
Motion to table, did you make
So,
that?
yeah, I'll withdraw my motion.
Oh, move that table.
I thought Joel moved to table.
Oh, I'm sorry.
No, I did not.
You didn't?
I thought I
Okay.
moved.
EJ moves to table. Second?
Second.
Seconded. Moved by EJ, seconded by Dan. This wasn't pretty, was it? And
But it's interesting.
Margaret will bring it back redrafted. All in favor of tabling signify by saying aye.
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 Aye. Aye.
Any opposed?
What's their sticky?
Thank you.
No talking during the vote. No talking during the vote.
That brings us to matters withdrawn, no action necessary for our information. Pending complaints, informational only. Boy, there's quite a list there, isn't there?
We've had a ton of complaints that have been filed in the last 3 weeks. It's just.
Boy, I guess, what's going on?
There's 2 more that aren't on here.
Jeez.
It's election season.
What's going, oh, really? Wow.
None from Michael Merritt though, so that's good.
Oh, yeah.
Slow down.
Have you
Just to
guys
give you
met?
an update on the status of Klein right now, that's still being, that
Going on in
was
Southern
remanded.
counties.
Just to give you an update, so EJ asked about it on the Klein case, it's been open since 2015. That was remanded by the Supreme Court back to district court, and at this point in time, they've got a hearing date set for next February. There's a briefing schedule, and this just happened. But they're still in pretty serious negotiations on a possible resolution of that. But it's in district court and not here at this point in time.
Isn't it just down to whether they're going to disclose a dash cam footage?
So from what I can gather.
We can't, because it's not on here for action, we got to be careful about how much.
Well, we're not going to take
information.
action.
Yeah,
but
Okay.
she
So
can
I
tell
think
us.
that Mr. Klein and the city, Burlington, are in discussions about the scope of the protective order in the federal civil lawsuit, and that's impacting their ability to get this signed done over here. But I haven't been moved in on those discussions, so I don't know exactly what they're still trying to figure out over a federal lawsuit. But I think ultimately, hopefully, they'll reach an agreement that involves release of any remaining dash cam video, like, any other videos that might be out there.
Is the civil action completely settled, or is it held up pending the resolution of this video?
I think it's done. I think that the issue is there was a protective order entered in the federal civil case, and the city feels like they can't release this video without violating that protective order. So I think they're discussing how to reopen the protective order issue in the federal case, but maybe not having agreement about the scope of that reopening. I think that makes sense.
It does, thank you. Well, that brings us back to you, Emily, board member training.
Do the withdrawals and.
Yeah, I'm moving those chairs.
Okay.
Would you like one?
So Margaret asked if I could come do some training since we have some new board members since the last time I did this training. My name's Emily Willits. I'm at the Attorney General's office. This particular training focuses on the board's role when you're presiding in a contested case. So this would be when the board decides charge a violation. If you find probable cause to think a violation of either Chapter 21 or Chapter 22 has occurred, you file charges, and you commence the contested case.
Do you want all the lights or just this?
That's okay.
Okay.
And just so I don't go over, how much time roughly do you want me to spend on this? Or
don't think you were allocated.
No, you weren't, but we were looking at 35, 45.
Oh, so I don't think it'll be that long, but
We usually adjourn by 7:30.
Yeah, let's try it at 6.
well, Brett, is there a,
No.
okay, yeah, you just go ahead then.
Okay.
So some of this is fairly basic, and I don't, I'm sure probably all of you have either are familiar with government bodies, but in state government, state agencies have these various functions, right? Rulemaking, regulatory oversight, investigating violations. This presentation is going to focus on that last bullet point, which is when we're in that adjudicative hat and you're serving as a decision maker in a contested case. And so there are some guardrails that we just want to make sure that state boards and commissions follow when they are wearing that adjudicator hat, so that we don't run afoul of the ex parte rules that I'll talk about in a minute. So go ahead, Brad. Some of this, again, I think is probably a process you're very familiar with. But this would be kind of all of the things that you all do before you would reach a contested case. So all of the things you did today, your meeting, reviewing complaints, deciding whether to close them, deciding whether you want Margaret to follow up and do some additional investigation. When you have a situation like you did in the Ripperger case or the Klein case that we were just discussing, where you decide we think a violation occurred here, we haven't been able to get it resolved through our informal resolution process, we're going to issue a statement of charges and begin a contested case process. That's kind of that last step. And once the contested case process starts, that's where these more formal separation of function and ex parte rules kick in. I will say though, I think it's important, even before you get to a contested case, just to remember you are wearing this hat where you're supposed to be approaching all of these complaints in a way that's balanced and fair and neutral as well too. So it's just important. And I guess, maybe even backing up to a higher look, zooming out, bigger picture, you're all here as volunteers, which we appreciate. We have this system of sort of participatory government in Iowa where we have all of these boards and commissions that are comprised of volunteers. But when you were serving in that role, although you're not a full-fledged employee of the state, you are a state actor. You're acting on behalf of the state of Iowa through the Iowa Public Information Board. So that's where some of these requirements kick in. You can go ahead. Right, so the next one. So when you decide that there's probable cause to find that a violation has occurred, that's where this more formal process would start. So, typically in the last couple of contested cases, you've had your in-house attorney prosecuting, right, Margaret? And then Margaret can be kind of in her role helping to facilitate communications with the board. But this is where on the front end, you have to kind of start thinking, how do we separate that prosecutorial function from that board decision-making function? Because just like in court, you couldn't have a prosecutor in a criminal case behind the scenes talking to the judge without the defendant present. You also can't have that happen during a contested case proceeding in front of a board or a commission. So you have some flexibility in your code section about who can prosecute one of these contested cases. If you have an attorney on staff, you could have that person do it and figure out how to have that separation. If the state is not the respondent, our office can potentially do it. So you have a board attorney selected, you can probably get somebody from outside if you needed to. But again, you want to just be sure you're kind of thinking at the front and okay, how are we going to separate the prosecutor from us, the decision maker? You have some options too as far as how to get the case decided. So under Iowa Code Chapter 17A, which is our state level Administrative Procedure Act, you can request an administrative law judge hear the case did in Rupert, correct? Or you could hear the case as a board with assistance from an administrative law judge, kind of facilitating the hearing. I would definitely recommend having an ALJ involved one way or the other, whether you send the whole case to the ALJ as an initial matter or whether you preside with an ALJ helping, because the administrative law judges that we have here in state government, they're housed at the Department of Inspection and Appeals, they're attorneys, they're highly skilled at what they do, they write really thorough orders. And then if I'm going to step in or somebody else is going to step in and defend the board's final order on judicial review, it's nice to have that really thorough, well thought out written order. They do charge a rate, an hourly rate, the ALJs for their services. So, I mean, it's fairly reasonable. It's much lower than what a private sector attorney would charge, but that is a consideration. If you decide to refer the entire case to an administrative law judge, as an initial matter, the administrative law judge would preside over that hearing, would receive the evidence, hear the witnesses, and then write up a proposed order. And then after the proposed order is issued, the either party could appeal, so the losing side, if the ALJ rules in favor of the board and says, yes, I think a violation of Chapter 22 of murder, for instance, the respondent could then appeal that decision up to the board. And in that case, you would have in front of you this proposed order and then publish a briefing on appeal, and you would need to decide, okay, are we going to affirm the ALJ's proposed order? Do we agree with it? Or do we think the analysis is wrong and we want to modify something? Or do we think the ALJ got it wrong? At that stage, again, you're lucky of Julie, who's experienced with this kind of thing to help you, but it's helpful too to have somebody advising you. So if our office hasn't been involved and isn't otherwise involved, we can potentially try to provide that advice or try to help you find somebody who can. The other thing that can happen is, let's say either side appeals, but you still want to take a look at the proposed order as a board, and we recommend you do that every single time and make sure you agree with the analysis, because ultimately the final decision that's issued is the decision of the Iowa Public Information Board. So all of you as a board own that final decision. So you can, on your own motion, initiate a review. You can say, well, we agree with this part of the ALJ's analysis, but we think this part is slightly wrong and want to rewrite that section, and you can issue a final decision. If nobody appeals and you don't do anything, the ALJ's proposed order becomes a final decision of the board, I think after 30 days. So there's a few different things that can happen, but I think what's important to know is when the proposed order is issued, you want to make sure you have a chance to look it over, discuss whether you need to review it at your next meeting, or given the time constraints you need to get on, for the special meeting more quickly. Are there questions about any of that process?
Have we ever had a situation where the board conducted the hearing?
Not yet.
No.
We've only had 3 contested case proceedings have been filed, so one of them, all 3 of those were heard by or conducted by administrative law judges, and all 3 of those then had a decision that came to the board for review.
And that's pretty common. I mean, most of, not all, but probably a majority of the boards and commissions around state government that serve in an adjudicative role have an ALJ hear their case in the first instance. Because like I said, they are very good at what they do. It's easier to get the case scheduled, so you don't have to get the entire board together. You can kind of get motion hearings and things like that scheduled with the ALJ on an as-needed basis rather than convening a public meeting every time somebody files a motion in a case to decide that motion. So it just makes it a little easier. These contested case processes, it's like a civil trial. It's a little more informal, but it is a lengthy, time-consuming process, as you've gotten a sense from this Rupert case that's now many years in, or the time case. So I think that's the kind of the downside of this entire process, quite candidly. But part of that is when you're administering a statute that imposes civil penalties, including potentially fines, the respondent has constitutional due process rights, and you have to provide that due process. So that's what this process is set up for. You can go ahead, Brad. I think that, kind of the main purpose of this presentation today is just to kind of remind all of you that once a contested case starts, you are functionally the equivalent of a judge or an administrative law judge in the sense that you need to be a neutral decision maker. You need to set whatever personal biases you have aside. You want to avoid talking about the pending case publicly or with any of the parties too much, because you don't want to be viewed as having prejudged the case or the outcome. So I mentioned here there's the Department of Inspections and Appeals, which houses these administrative law judges, has a code of administrative judicial conduct. It's in their published rules, which you can find on the legislature's website. Or we can get a copy to anybody who wants to take a look at them. Some of those rules apply to boards and commissions too, in this presiding capacity if you're presiding over a hearing. So it's good to review those should you have a case coming up. But it really touches on some of the things I just mentioned, the importance of impartiality, neutrality, and avoiding conflicts of interest and things like that, which we'll talk about a little bit more. Go to the next slide, Brad. And then similarly, our Iowa Administrative Procedure Act, which is Chapter 17A of the Iowa Code, has specific provisions in it about ex parte communications, and that would be when the presiding officer has conversations with one party or the other outside the presence of the other party, and that's prohibited under the code. But the code also goes a little bit farther and talks about if you're participating in the final decision, so that would include, like, let's say Margaret's helping the board procedurally along the way, you can't have, also advocated, you can't be also working with the prosecutor at the same time. So that's where I think it can get a little bit tricky for a small agency like this one, where you only have at any given time 2 or 3 employees. So again, when you charge up a case, you want to think really carefully on the front end, how are we going to staff this in a way that we don't run afoul of these rules. In the Ripperger case, the county assessor actually raised this as an issue towards the end of the case, alleged there had been some improper communications among staff of the board. The ALJ found that that was not the case, and the district court reports all the way up agreed. So, in that case, nothing improper happened. It was, the allegation was based on sort of was like chatter that occurred during a break during one of the meetings, and I think the court kind of said, well, it's hard to even tell them. Folks were really talking about this case, and it was pretty harmless, and nobody said anything that hadn't already been said in open court. But that's the kind of thing you just want to be cautious about, because if you give a party, if you give the respondent in your case an argument that they wouldn't otherwise have on appeal, which isn't helpful. The code does make it clear that a board like this one can participate in the probable cause stage of the case and then preside. So this is a little bit strange, and I think for attorneys locally who don't practice in this administrative law space very often, and then they encounter one of these cases, they kind of go, what is going on here? Because you could never have a situation like in a criminal case where you have, the judge making the decision to charge and then also presiding over the case, right? That would cause some constitutional issues. That is allowed here in this kind of administrative type of proceeding, and the Iowa Supreme Court has said it's okay. The U.S. Supreme Court has said it's okay too. But I think just be aware that it seems a little strange, I think, especially I found when I deal with opposing counsel who maybe hasn't been in this administrative law world very much. This is really weird. The board charged up the case, and now they're supposed to neutrally decide it. It's So I think, again, it just goes to the importance of kind of keeping that neutral decision maker hat on when you're in the presiding officer role.
So when the board is conducting the hearing, how do you handle evidence issues?
Yeah, good question. So that's where I think having an ALJ involved is really helpful. So it sounds like all three of your contested cases, you just had the ALJ do it.
That's correct. And just
wholesale.
totally do it, not just insist.
Yeah, so some state boards, like the medical board is an example, that do disciplinary cases for doctors. They will have, it's actually a committee of the board that hears the cases with an ALJ sitting there with them, who will then rule on things like procedural motions and evidentiary issues. But then the board still gets to hear, see the witnesses face to face, and see the demeanor and make credibility determinations. And then the board makes a decision, and they kind of tell the ALJ, here's our decision, could you please write it up for us? So there's a couple different ways that can be done. But usually those administrative law judges are really helpful as far as ruling on evidentiary issues. And I don't know if your attorney, well, if your attorneys or not, in this 17A Administrative Procedure Act world that we're in, the rules of evidence are very relaxed. So the rules of civil procedure apply to certain procedure, can apply to certain procedural aspects, but on the evidentiary side, the rules of evidence don't really apply. You can still raise objections, like you can raise a hearsay objection. Usually all the evidence comes in and it just goes to the weight of the evidence. So it's a less formal kind of proceeding.
So Emily, in one of our contested case hearings, we have a board member who wanted to go sit in and watch the entire hearing. What's the view on that?
I mean, I think if you kind of have to make a choice under 17A to refer it out to an ALJ or not. And I suppose if it's a public hearing,
Yeah,
anybody
should
can
be.
The
watch.
hearing's open. I think
Yeah.
a board member could.
That's a good point. It's a public hearing, you
Yeah.
can just go. I just think you wouldn't want to then be like asking questions as though you know.
Right,
You know what I
right.
mean? But you can certainly watch.
Well, but they would have to, because sometimes you have breaks, they have to be sure not to engage with witnesses
Right.
during any breaks.
Yes, definitely. Yeah.
I think particularly for trial attorneys, the world of ad law seems kind of wacky.
Yes.
That the people who make the charging decision also adjudicate. But that's the nature of administrative law, that you have the expertise in one location.
Yeah.
You investigate, you charge, you adjudicate.
Well, and it's interesting when I've talked with people from other attorney general offices around the country at like trainings that I've been to hear how different states do this, and everyone has set up. Some states have it set up differently, but they have their own set of problems. Like some states have all the ALJs housed within the attorney general's office, and then the attorney general is also prosecuting them, and that creates a whole other set of problems. So it's a complicated puzzle to figure out. I think we have a pretty good system here, but you do have to just be careful and think about which hat you're wearing at which moment. We can go to the next page. I think I got a slide out of order here. This is just back to the code of. Okay. Yeah. So this is back to that code of administrative judicial conduct that I mentioned previously. This is just kind of the introductory language to it. It's more detailed, but this kind of sums up the goals of the administrative code. And then there's more specific rules, like I said, about things like conflicts of interest, when you need to recuse from a case because maybe you are related to somebody that's involved, that type of thing. We can go to the next slide. So this is something that I wanted to mention. So it's kind of what we were just talking about. So the Iowa Public Information Board as an agency can do all of these different functions, right? You as a board can investigate a complaint, make a probable cause determination, and then serve as the presiding officer. But you can't have the same individuals necessarily serving in all of those roles. So again, this is particularly complicated for smaller agencies. And you just want to be really thoughtful at the beginning of the season on how you're staffing it. So however the new rules flow through the staff people too. So it's not just that, you as a board member can't talk to the prosecutor while about the case while the case is pending, but also, if Margaret's helping the board out with the case, she also needs to be careful about that. Vice versa.
Right, so what we've tried to do, and it's easier to do when we have three people than so we just have two, and it's easier with the third person who's another attorney, but when we have a complaint that comes in, the initial when it's investigated by our office, it's not investigated by me, it's investigated by staff. And so we can have, and then they, that information is presented to the board in the forms of reports, as you've seen a number of different times. And if we do hopefully a prosecution, then if we have to have a prosecutor, then that would be the attorney two position that could actually do that prosecution rather than having me serve as that. Where we ran into problems before is I used to be the attorney two. And so on both the Klein and on the Ripperger case, I was involved in the actual investigation and putting together probable cause reports and so forth, which then meant that I was precluded from prosecuting because I can't call myself as witness, and I was also precluded from advising the board on the actual outcome of it because I was involved in I was involved all the way through, so it would have been the same person doing all of those roles.
Yeah, and just to be clear, if you have a contested case pending, it's not that you can't talk to your in-house attorney at all ever about anything. You just can't talk to him or her about that case. So it's not like total bar on any communications. You just can't have conversations about it. There is case law that talks about how public officials and public servants are afforded a presumption of, impartiality and good faith and fair dealing. So we will assume everybody's behaving the way that they're supposed to. We go to the next slide. These are just a couple of the cases that kind of talk about this principle that under the Constitution, in this case, the U.S. Supreme Court case, was a federal constitutional case, that it doesn't violate due process to have an administrative agency both investigating a case and then presiding over the adjudication. Again, it might be more problematic like in a criminal prosecutorial context. And this is what I was just sort of mentioning. There's a presumption of honesty and integrity, and we're going to assume everybody's respecting the boundaries that they need to be set. You can go to the next slide. And then these are a couple of Iowa Supreme Court cases that kind of looked at variations on that question. In that 1994 case, there was a question about whether our office, the Attorney General's office, could be kind of providing legal advice to a board, like I might, or trainings like I might be, like I'm doing today, and then we could then step over here and prosecute a case for that same board without creating either a constitutional problem or the appearance of a conflict. And then the court said that's okay, again, we're going to assume people are respecting their boundaries and not having improper conversations. And then the second case was a case where the executive director at that, in this case it was one of the local civil rights commission, the executive director was advocating for the complainant, but also at the same time advising the board while there was a pending contested case, and the court said, no, you can't have that. So that's where you have to be careful. So this is back to 17A, which is the Iowa Administrative Procedure Act. I just wanted to provide you with kind of the ground rules for ex parte conversations, which are not allowed. So these are kind of some of the definitions of the statute, but kind of same principle, but you need to, when you're in that presiding officer role, when you're presiding over a contested case, you need to make sure you're not having communications with any part of your person who has a role to play in the case that's going to be in front of you. So any witness I don't know if there's anything else. Other, questions about any of this?
I guess I thought on the previous slide, ex parte communications prohibits speaking with people without notice and opportunity for the other side to be heard.
Yes,
It's
that's a
not
very
that you
good point.
can't talk to them at all.
That's right, that's a good point. So you have, if you want to get the parties in front of you to discuss some issue in the case, whether it's have a hearing about something or scheduling, you can do that as long as you include both of them. That would
But
be good.
they at least have the opportunity. So
And
you
yes.
couldn't come and settle the Ripperger case without Megan having notice and opportunity to participate as well.
Right.
Which she did.
Yeah. This happens, I'm an attorney. If I'm scheduling, if I'm communicating with a judge in one of my cases about even just scheduling, when you're available for a hearing, there's always going to be copying in the other side. So there's no question that you were improperly communicating with a judge without the other side involved as well. Same thing with all of you. And again, you want to have an independent prosecutor. And then this can get a little tricky. So if you have an ALJ who issues that proposed decision, you've got to figure out how to review it. You might want some legal counsel along the way, or maybe you don't, and you feel like comfortable just doing it as a board. But you have to think about that because you can't get your in-house attorney to help you review it because they probably prosecuted the case potentially. So again, just thinking about who could be, if you feel like, or let's say you feel like you want to modify something in the order and issue a new written order and you want help writing it. Again, might be something our office can help with if we haven't been involved in the case otherwise. Maybe we sometimes get somebody from another attorney from another state agency to help out. So you just want to be thinking about how you're staffing it. Next slide. And these are just some kind of additional things to be aware of in your role. You are public officials in this role, so you're subject to some aspects of the law. I think a lot of this is common sense. You don't want to write, you have a respondent in a case who says, hey, I'm taking you out to lunch, and you've got a case pending. Think twice about that, right? And accepting gifts. The Iowa Campaign Ethics Campaign Disclosure Board, right? They're a good resource for questions about this type of thing. I've found their staff is pretty helpful, and I will refer people over there if they have questions about things like gift law, so don't hesitate to reach out to them. Lobbyist rules is another thing. If you have your legislative committee, you propose legislation, you want to make sure whoever you have advocating at the legislature is, following lobbying rules if they're actually lobbying.
Which I'll tell you, I am right now. I'm registered and I do the trainings and all the other stuff.
Okay. Yeah. And that raises a good point. One thing you want to be careful about, so we have a lot of boards and commissions where you have a lobbyist on the board who's maybe a lobbyist in their professional life. Otherwise, now and then there will be situations where a board member shows up at the legislature and starts kind of talking about things, but they weren't part of their board's official lobbying agenda. And so I think you want to just be careful that you're not individually advocating for a position for this board without the board having first looked at it and agreed that that's something we want to run for. Conflicts of interest, I just think it's always better to ask. So if you have a case or a complaint that comes before you where you've got a close relative involved or your workplace is involved, or some other professional association that you have, you want to be thinking about, is this a case that I need to abstain from, or and if you have questions, certainly Margaret can help you. We're happy to field questions, but you just want to make sure I think it's always better to ask questions. It might be that there's not a problem and you want to participate, but it's just something else to always be thinking about, so you don't have the appearance of a conflict. Because again, ultimately, although I haven't had a great track record with the Ripperger case, I want to be able to defend, I or whoever else is defending your decisions on appeal, we want to be able to do that successfully. And we don't want these side issues, ex parte communication conflicts of interest kind of get in the way of the narrative. I always like to mention this because it's a question we get. So for purposes of the Iowa Tort Claims Act and just generally your board activities, you know, if you're ever, hopefully you'll ever be sued if you are in your official capacity because of work you've done on this board. You can have a defense from the Attorney General's office and an indemnification in the event of any monetary damages. Usually if people are individually named as board members, we can get the board itself substituted in as the as the named defendant in the case and try to get those named people out, but just like to assure people of that. So, hopefully it won't come up, but now I know it does. Any questions?
Thank you.
Yeah.
Thanks.
And, you know, you've got a copy of the PowerPoint presentation. That's for you to take and put in your board manual so that you have that available.
And I don't know if I have my email on there or not, but Margaret has it. I can do this too, so if you have questions.
No.
Answer them.
Have you heard from Susie yet? Okay.
Okay. Yes, somebody was going to be here for that. When we get to the legislature.
Really?
She's not here yet. She's from Tennessee.
Well, she had hot put it over because we're going to be there in no time.
Yeah, I told her we'd probably be there about 3, but she can't get up here unless Brett goes there.
Committee reports then. Let's start communications.
Brett, did you have anything on communications?
I do not.
Oh, and here we are, legislative. Shall we skip over that and come back when whoever's coming comes?
Yeah, we could do that, because she should be here. She probably should be here by 3, but one of us wanted to go down and let her in because she can't get into the building.
Does she have a phone number to call?
It's on the door and it's,
Yeah, so it's Brett's number, so we'll get that. But we can go ahead and work on the rules thing if you want to.
Okay.
That'd be fine.
Let's go on to the rules committee.
Okay. As you recall, we have had this rule that's second time up. Only this time is just to take those 2 items off. And if you look in your packet, it's ARC 6540C, and all it is to remove those 2 rules that either are inapplicable or that are one of them. The second half of rule we've already removed, so it's sort of like it was a cleanup thing more than anything else. So that's been filed, and I think it was on October 11th was our deadline for written comments. October 11th was also when I appeared before the Administrative Rules Committee over at the Capitol, and didn't really have. We had one question, but it had to do with I think something else, and I just said, just give me a call because it didn't really have to do with what we were proposing. So next week, the time frame will run where I can go back in and ask to adopt the rule.
Good.
But I need to have a motion in order to approve the rule again because we've now gone past the ARCC hearing and the public comment period of time. So I just need a motion to approve ARC 6540C so that I can then go in next week and put the adoption notice up.
And all it really is the repeal of a couple of different rules
That's it.
that would have caused major due process problems if we didn't follow.
Right. These are things we can't do. So it's nice not to have them in the rules.
Can we get a motion to approve ARC 6540C? substantively, it's been before us before. Margaret's explained what we're repealing and why.
But I can do it again. It's a lot of, if you get to that, it's ARC, this is what it looks like. The first page is all the stuff that I have to file in order to get to the second page and the 2 lines that are the actual substance of the action. But the rest of this is all the requirements in order to do any kind of a rule change. And it just changes like whatever they feel like it. So every year we get new rules on how to do rules.
Anyone comfortable making a motion?
Where can we, I'm sorry, I'm sure you probably told us this before, where can we find the specific sub-rule?
Those 2 rules are in our rules. And that's on the website. And
Sure.
I think you probably have the rules in your, they're not in there. No. Historically, we've had a copy of the rules in the board book, the board manual.
One of them was the rule that authorized the
497.
board to just
Go
order
to,
things disclosed, no due process.
Across on the red banner,
Basically, 21 point,
and then where it says administrative, it should pull up a link to the,
Got it.
yeah.
Thank
Rule
you.
2.1 sub 6 is administrative resolution, and it reads, to assist with resolving complaints in an informal and expeditious manner, the board may, at any time during the complaint process, order administrative resolution of a matter by directing that a person take specified remedial action. A board order directing remedial action shall constitute final agency action for purposes of judicial review under Iowa Code Chapter 17A. That rule is beyond the scope of our authority as outlined in Chapter 23. We have a specific process where we have to accept a complaint and then engage in negotiations for informal resolution, then do a formal investigation, and then have a probable cause review of it. And so, and file a contested case that if we have specific things that we want a party to do. And so this was added after the board came into place. So this was added, I think, in 2013. But it's not, oh no, it's in 2017. It's not something that we basically can do. So this is be by ordering something without any due process. So that's the reason that there was a recommendation, a request, and approval by the board to remove that. The other one is in 497-4.17, which is a 17A reference, Iowa Code, Administrative Code 17A, and it says a party requesting a contested case proceeding may withdraw that request prior to the hearing only in accordance with agency rules, unless otherwise provided a withdrawal shall be with prejudice. Well, a contested case proceeding that we are prosecuting, it's the IPIB against a respondent. So this made no sense. We don't. If we want to withdraw it, we just dismiss it. We don't withdraw it. We just close the case. So that while it's appropriate for some other agencies, and it's not really necessary for us. So that was the reason to remove that.
So if a party makes a motion to withdraw their complaint, then it'd be without prejudice moving forward, and they'd be able to refile the same complaint? Or I guess I'm a little confused.
Well, this is a contested case proceeding. And a contested case proceeding is filed by the IPIB against a respondent. So if we filed a contested case proceeding and then a period of time later decided that we don't want to do the contested case proceeding, we wouldn't be withdrawing it. We would be dismissing it.
Sure, yep, okay. Yeah, well, based on those explanations, I'd move to approve the proposed rule changes.
Moved by Dan, seconded by EJ. All in favor, signify by saying aye.
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 Who is it that's coming to talk to us about the legislative?
The person coming is from Iowa City with the county attorney's office there, and she's this Susan, is who said she was going to be here. She had to drive over from Iowa City, and she emailed me at like 11:15 saying she was on her way. I know. That's a long call. But she had those secondary comments. And I don't know, did everybody get a chance to read the comments? That was what we requested. That I notified various groups, and what I did is I sent it to the AG's office, I sent it to the County Attorneys Association, and I sent it to the Prosecuting Attorneys Council, which are actually both the same people for the County Attorneys Association and Prosecuting Attorneys. So I received back the comments from Polk County Attorney's Office, and then comments from Lynn County Attorney, and then the comment that came later that was from the Johnson County Assistant County Attorney. She's one who said she was present here today. They talk about all of our legislation, even though basically what I was requesting was just comments about 22.7 sub 5. So I don't know if you want to go ahead and talk about 22.4, which is the language for acknowledgement of record request. That was continued over at the board's request from the last meeting.
I think we saw the legislative proposal. Board discussion.
Right. Well, we haven't approved it yet. It was tabled last time till today's meeting. So those last time the board agreed to refile the 60 to 90 day language. So that's already taken care of, and it'll be filed. We actually just training again on how to file this legislation. So once we have a decision on this, I'll just go ahead and file that. We do need some directions as to, and I have no problem doing this, putting them as 3 separate pieces of legislation, or if we want one as a Chapter 23 legislation, and then the other 2 are Chapters 22, have those filed together. That's, that doesn't, the only difference that makes is that it's clean if it's filed by chapter. However, because the legislation concerning peace officers' investigative reports tends to go to a different committee than 22.4 matters would go to, I would, instead of going to state government, it tends to go to judicial or to law enforcement, I think, or, so filing all 3 of them separately, although it's more work maybe for me because it's 3 different subcommittees that I could potentially be going to, I think it keeps those 3 separate so that one of them doesn't get dragged down by another. Is she here? Oh, okay.
We have her written comments. I'm not sure. She wants to come speak.
Now that Margaret's asked my opinion, but I know it's more work, and with Margaret, it increases likelihood that you may get forward momentum and stuff. Yeah, just my opinion. I just wanted to add another voice to strategy.
Yeah. And there are 3 separate ideas, I guess, is the best way of looking at it. Even though 2 of them are Chapter 22, they're different.
Just bundle them up, but that's on my mind.
It is something like that.
So she's going to ask us not to submit original.
Right, we did. I think I can comments I got back, there was nothing supportive.
I know how that feels.
Yeah. And there were some comments about the changes on 22.4, but the majority of the comments were addressed at 22.7 sub 5, the peace officers investigative reports. And so you should have that language. That was included in here. There's two different pieces of legislation that we're talking about, and people need more copies of that. I've got some of that, but it's attached in your board packet.
And you're Susan Nearing?
I am.
Okay, I think we're ready for you. Okay. If you want to move up here, we've got 3 people on the speakerphone.
Okay.
Either drag a chair or stand near the microphone.
Or speak loudly.
I don't know if you're going to get that chair.
Where is the mic?
What?
There.
There's one right here. Why don't you sit here?
That's a good idea.
And I will go.
Thank you.
So I guess you weren't going to get that chair in here. Over the table.
Good afternoon.
Hello.
Do you want to take one, do you want to take them in order, or do you want me to just discuss my comments in general? Well, the only ones that we have that are currently on the agenda for today is the proposed amendment to 22.4, which is the acknowledgement of record request. And the big one, of course, is the 22.7 sub 5, which is peace officers investigative reports.
All right. Thanks. I appreciate the opportunity to address the board today. I'd sent some materials in advance, so I certainly don't plan to read all of those remarks, but I just wanted to provide some
tell everybody who you are.
Yes, I was just going to say, I was going to provide a little introductory information about myself before I go into my other comments. My name is Susie Nearing, and I am an assistant county attorney in Johnson County currently. But I started off my career as a prosecutor in Lynn County, where I worked for approximately 12 years, 12 and a half years, and then I moved over to the civil division in Lynn County, and I advised the Lynn County Sheriff's Office, and then now the last 12 and a half years or so I've been in Johnson County working in the civil division. So not all of the county attorney's offices have the luxury of having a civil division. A lot of them are too small, so one county attorney has to wear all of the hats for that position, which is a pretty big task. But particularly in this civil division, I am uniquely assigned to advise the sheriff's office, and I regularly correspond with the staff in the sheriff's office that are answering public records requests. In addition to that, one of my other duties in the civil division is that I respond to litigation against the sheriff's office and against the county in general. And I mention that because there's a lot of overlap between the the records requests and litigation. A lot of times, some of the earliest phases, people make that initial inquiry, so they evaluate what they would be able to get access to in connection, what records are there, what does the record show. The attorneys are looking at whether there is enough to bring litigation against the county. We certainly understand that that's our responsibility to provide information. I also provide that in the context because from a legal perspective, the case law that's come out in this area has actually come out in the context of litigation. So not in the, it's sort of in the course of a lawsuit against a governmental body, there's been discovery disputes about what kind of records need to be turned over. And then the courts have weighed in and used the public records law sort of as a reference and a guide for those decisions. And so I mention that again because I think that's some of the framework where we're seeing the case law come out in regard to some of these. The most significant case that I think that's really sort of people focused on a lot came out in 2019. which was the Mitchell case that arose out of Lynn County. So that's just some background. These are issues that I work with pretty much on a weekly basis and have been doing for the majority of my career. Obviously, the second half more so than the first half. But I mentioned my experience as a prosecutor because unlike public records requests that come up in the context of all of, many other contexts, we have a dual role in addition to being able to make sure that, people can get access to information about what the government is doing. As a prosecutor, we have special obligations to maintain information in a manner that does not impede the ability of a defendant to have a fair trial. And especially in this media-driven world now, if all the information is out there on the internet for people to look at before we have a trial, we can't have a fair trial. We can't get a jury panel if all of that stuff is out there and available. And we have ethical obligations as prosecutors to make sure that information doesn't get out there. And also we have ethical obligations to make sure that law enforcement doesn't release information that would impair the ability to have a fair trial and that would unfairly inflame a potential jury panel. Once that information is out there, anyone who wants to highlight parts of it has no duty to put it all in the context. It's whatever parts they want to. Once it becomes public record, it's fair game and it can be used for any purpose. And we work very hard and very diligently as prosecutors to try to maintain, respect that, the integrity of those investigative records so that we can, so that if we go to trial, that we can have a good trial record, that we can have a good jury pool. And then there's also the other side of that, which is investigations which turn out to exonerate somebody. But if all of the gory details are released to the public and people are able to excerpt that information and release it without any guardrails about that, people can essentially be convicted in the court of public opinion based on not a full record or not the full investigation, but only parts of it. So I know that's a lot of background, but I took the time to write that in my notes to you because this is a small area in the whole scope of what you do in public records, but it has such an incredibly vital role for our, really for the fundamentals of having a, civilized society. We have to have a functioning criminal justice system. And there are balances to be made about this. In this particular section, that 22 7 sub 5 about investigative reports, it's a tricky issue because it does put all of those things into play. And the one, I don't know, this is a very this is a difficult issue to strike that balance, and I don't know that, I think it's a big task to figure out what is the best way to write this statute to strike that balance. But I am very concerned that the proposal as submitted will actually make the current situation, which is a little bit, we're still having quite a bit of litigation about this. I think people feared there would be more trouble after Mitchell, but I don't know if it's been as bad as people had anticipated. I think it's been a little bit limited to the context of discovery. But the proposed changes, I think, would just absolutely just rip things open and turn everything on its head and cause all sorts of problems. The primary reason, big picture-wise, is that instead of saying, when you have a sitting investigation, you say, well, this is an investigative report, we can't turn it over. And sometimes there's good reasons for not turning over investigative reports even after the investigation is over. But the way this is written is that it says, so investigative reports are confidential, but if they are, so they're presumed to be confidential, except for the immediate facts and circumstances. It says it has a couple other modifiers, but the immediate facts and circumstances of the incident except for in the unusual circumstance where turning that over would impede things. And so I think when you read that in the context, that doesn't mean that there's a presumption that everything that's collected as part of an investigative record that has something to do, that has to do with the actual contemporaneous reporting becomes open game. And if the burden got shifted here, so we have this strange test, it's confidential, but if it's immediate facts and circumstances, then we go to this other list, and all these things are presumed to be immediate facts and circumstances. And I'm concerned that that list is not really even a common sense description of immediate facts and circumstances. It does include a number of things that I think are already available. If there was an interest in making sure that there was clarification that those things were things that didn't come within the context of investigative records, I think there might be another way to do that. But I would not recommend defining immediate facts and circumstances in the manner that is being proposed here. And that is the particular issue that brought me to drive all the way to Des Moines to talk to you today, because I feel so strongly about the fact that this is the wrong direction to go. That this list would create an enormous amount of litigation. I described in my comments, provided some examples on various different items that are on that list that I would not recommend, but the one that is the most troubling to me is the one that talks about contemporaneous audio and video. Because it is contemporaneous audio and video that is related to the crime or the incident. This does not just, I think that would easily be and not irrationally interpreted to mean not just an actual video of, if we take, for instance, a shooting, but the incident covers all of the officer contact that would be related. So the incident could just be defined as all officer involvement with members of the community in connection with the shooting. Each one of those officer involvement could be brought under that umbrella. And so it's very common practice now that when officers are taking witnesses' statements from folks at the scene who actually saw what happened in events, that they keep their body cameras on, so that is the best recording of the witness statement. They also do, documenting crime scenes by using body cameras and moving around the crime scene. There's all sorts of information in there that are clearly sort of in the original format of what an investigative report is. It comes within what we would consider to be an investigative report. What happens in a big incident, and one of my responsibilities was handling homicide investigations when I was prosecuting. When you have a large homicide investigation, there may be 50 or 60 interviews that get conducted in the first couple of weeks in relation to that. Maybe even 25 or 30 just that first evening or morning when the homicide occurs. And then there may be 10 or 15 or 20 or more suspects initially. The investigation usually sometimes will go very broad, and then as it develops, it narrows in. But the way so you have a large group of officers respond. Every one of them has body camera. They have their car cameras. You have the overlapping body camera, so one officer is interacting with somebody, but they're picking up the other officer's interaction with somebody else. To try to sift through that kind of body camera footage and figure out what is something that would be protected under this and not protected under this, it would mean reviewing, a single homicide investigation. It could be truly hundreds of hours of video. There's no way to shortcut that kind of review other than to actually watch the video to determine what would come in and what wouldn't. And those are the kind of situations that I'm really concerned about I realize that's not going to be the everyday sort of thing, but for me, as a person who has spent a career doing this kind of work, that leaves out it's me where that would just be, there's going to be a lot of public interest in a situation like that, but it's also a situation where the burden for trying to then establish which of these things would substantially impair the investigation, which ones were in, which ones weren't, it's just enormous. Now, I mean, I'm giving you kind of the dramatic case, the big murder investigation, where a lot of people are present and currently working on a case reviewing a shooting on the pedestrian mall in Iowa City, where we did have literally 100 witnesses to the actual crime. But it cuts across much broader. If law enforcement and somebody could just presumptively get all the contemporaneous body-worn camera footage for any incidents, regardless of whether it's an ongoing investigation, or at least demand the stuff that's related to it be sorted in that manner. It would require every law enforcement entity to employ a staff of people to do nothing but regularly review these documents, and it would be crippling. I also think it would lead to endless litigation. I kind of mentioned in there also some of my comments about there's the provision saying somebody believed to be a suspect. Again, in the situation, in a homicide case, it's not uncommon if there aren't all the eyewitnesses to the actual murder that there may be a number of suspects initially that are being developed. And at some point, some of them law enforcement may strongly believe are suspects, but they don't charge anybody until it rises to the level that there's sufficient evidence to say that particular person is. But under this sort of standard that was articulated here, I think somebody could reasonably ask a week into a murder investigation, we'd like to have we'd like to have the names of any suspects. Because it's on the list of the immediate facts and circumstances, we'd like to have that. We'd like to have any reports that name somebody that you believe may be responsible for this. And then we'd have to, as a law enforcement entity, affirmatively resist or request and maybe even stop. We maybe have to go to the point of getting an injunction. I don't think that's the kind of place that you want to go with this. I imagine the list was prepared in a manner that was well-intentioned, but this particular area has so many ramifications that, I thought about whether I would propose some different language here, and I thought, this is one that has to be taken extremely thoughtful. I didn't want to rush and just prepare something in a short period of time. I know that this has been proposed before. This is the first time that I knew that it was going forward to the legislature. When I read it, I had set aside many other things that I was doing in order to prepare my remarks to you because I feel so strongly about this. And I also feel that I'm uniquely positioned to talk about it because I have served in those different roles and done that over a long period of time at all levels of criminal prosecution and then also at the various different levels of civil representation of law enforcement entities. So, like I said, I would urge you to. I don't think this is ready to go forward. I think that if it's meant to be a fix, it's actually going to create more problems. So those are my main remarks about 22.75. I did want to make a brief remark about 22.4, and then I didn't get a chance to write that one out as extensively, and my comments aren't as extensive about that. But my recommendation would be, at the very least, I have concerns about this overall, and I guess I'll tell you my overall concerns about this. There have been some, beefing up of the enforcement provisions of this, that now under 22.10.3, there's a minimum fine or minimum civil penalty of $100 for a violation, regardless of whether it was knowingly. And then a $2,000 minimum penalty for a knowing violation. We've seen, and that's for of any aspect of it. And I don't think this board is, finding people. It appears to me that your role has been to try to really work through these disputes with people and move these, try to get these issues resolved so that the people get the reports they want. I applaud that. I think that is a great approach. But the way the statute's written, people can bring now, that they can file their complaint in district court, and then they can ask for these penalties for any violation of the section. We just had a case, a situation arise where we received a public record request to public health for essentially all of the communication that our public health department had with a certain school in the 2-year period, sort of the height of COVID. This was, the response to that after we did the search was that there was going to be over 1,000 emails to that school during that period of time. Some of those emails were detailed emails about particular students who had particular health issues about, about certain children that had individualized protected health information. Other informations were communications about COVID that were general communications. Some of them were about flu. They were a whole host of things. But we had to sort out what to do. There's 1,000 emails, all which may or may not be embedded with protected information, is not something that you can just evaluate in a 5-minute review. It's extensive. And when we did not respond, we kept communication up with the requester. And when there were some health issues that came up with the custodian who was out for a little while and didn't get back, as soon as she came back, she got back in touch with the requester. She said, here's what the situation is, I'm working on these, this is what I'm doing, I was out for health reasons. And he filed in district court seeking sanctions and claimed that it was a knowing violation. And I was seeking the $2,000 minimum penalty for not complying. That doesn't even come to you guys. We got all the records, did the sorting, got the records to him, and asked him if he would drop the litigation against us, and we were told that he would not. So eventually he did back down, but if he did not, we were going to actually have to have a trial on that over the issue of whether or not it was knowing. I mentioned this incident for a couple of different reasons because I want to point out that now that they can be brought in district court and there are these mandatory minimum penalties, just failing to provide an estimate of fees and an approximate date, somebody could file an action just based on that, even if you actually got them the reports, just because they're mad that they didn't feel like you did it timely enough. And then we have to pay the cost of litigating that. But if it's kind of in a gray zone and they prevail and the court says, well, it's a pretty close call, but I think that is a violation. It wasn't knowing, but it is a violation. We're going to fine you $100. And by the way, we'll also grant that attorney award fee for $5,000 for their attorney to bring this action against you. And I assure you that the attorney who was suing us in that situation regarding the public health records would have submitted a substantial attorney fee award request against us. I know what his hourly rate is, and it wouldn't have been cheap. We were afraid to even call him to discuss this because every time we called him on the phone, he could write that down as another billable hour that he could seek as attorney fees. We were trying to do our best to comply, but that's the kind of situation that we're starting to see more and more often where these public record requests are being weaponized against public officials. We're not trying to avoid our responsibilities, but I'm here to try to talk to you about some of the things that are actually going on out there on the streets that are creating problems for us as governmental entities. And That time it wasn't a law enforcement entity, but, our public health department has had a hard enough time dealing with all sorts of other things. They complied, but it was a very frustrating and anxiety-provoking situation for them, the way that they were being approached about that. So when you add additional requirements that are mandatory in the statute, there is the potential that somebody can ask for sanctions for that, and then you take the chance. You just agree that you're going to be, you're actually ahead just saying, okay, well, just fine me rather than fighting it, because if you fight it in district court and you have to pay their attorney fees, you're even in a worse situation. So I also think that the first part of this says, upon receipt of request for public records, the lawful custodian shall acknowledge the request promptly by providing contact information for the lawful custodians. That part of it, I understand why the board wants to go in this direction. I made comments when we were talking about the rule. I felt that the 2 day original proposal was really, really difficult because of the huge range of governmental entities that have to comply to this, and so many folks that are not, full-time professionals who may be subject to this kind of rule. So I have issues with that. I see now that it's been, changed to being a little bit, would allow a little bit more interpretation for promptly. But it also says promptly providing an estimate of any fees and an approximate date of release of the records. The second part, those things may not, a lot of times, a lot of routine requests can be turned over right away, so there may not be any fees. The statute says if it's going to be less than, I can't remember whether it was under 50, if it's going to cost less than 50 cents or whatever, you don't charge them, or is it $5? Whatever the
the first half hour.
The first half hour, and I have no problem with that whatsoever. But at any rate, a lot of times, a lot of requests are covered by that, and then the approximate date of release of the records. So it says, when you read this all together, it says all of those should be promptly provided. Sometimes there may not be any fees at all. In a situation like the one that I just described, where we got a request for 1,000 records, well, that was one where the way it was requested, it said any emails to, and it gave us the email addresses. So it was pretty easy to do the search parameter. The real rub was figuring out which ones had protected information with them. But even then, with 1,000 emails, we couldn't promptly, like within a day or two, figure out how many of them were going to be impacted with protected health information. We had to figure out a variety of different ways to search the documents to be able to locate those. And when we got the request, we didn't have any idea how long it would take. Providing a prompt response saying, we got your record request, this is the person that you should be in contact with, that can be done promptly. The other two, I think that could generate a lot of litigation, particularly with the one that we just had. You could ask, added on another thing saying, we were knowingly not turning it over, and that you didn't promptly provide an estimate of the cost, and you didn't or the time when you were going to have it ready. And I would hate to see us go down that road and provide a tool for people to just use this as a way to kind of pressure governmental entities into being doing the right thing. We have a lot of confidential information that we are not supposed to turn over. Public health has all sorts of information that we have federal duties through HIPAA and all sorts of other mental health information. And there's many, many different layers outside of just the public records law in terms of the different sources of confidentiality. And as governmental entities, some of those are affirmative duties where we can be penalized for turning over information that we're not supposed to turn over. So we have to do our due diligence. It's not, I don't think it's, For me, the criminal context is the part that's really close to my heart because that's something that's going on day in, day out, and every one of those criminal investigations brings up some of those similar issues. The public records request to public health departments, it doesn't happen as often. That's probably more unusual. But I think the way this is written, that would be my primary objection to that. I still have concerns about the possibility of litigating a lot what promptly is. If you were very insistent on going forward with it, I would ask that you, at the very least, like I said, strike the last part of the sentence after the comma, after a lawful custodian, that says an estimate of any fees for the records and approximate date of release. I think those issues are covered elsewhere, and it's not necessary to add that in here to get the effect that you are looking for. So those are my comments. If you have any questions, I'd be happy to answer them. I really appreciate your time and letting me come to speak about this. I do have a very tight agenda of things, but I felt this was extremely important, and I know you have a lot to do as well, so I appreciate your time in hearing me out on this.
And I would note that 22.3 sub 1 does say that fulfillment of requests for a copy of the public record may be contingent upon receipt of payment of expenses to be incurred in fulfilling the request, and such estimated expenses shall be communicated to the requester upon receipt of the request. So it's already required. Mm-hmm. So I think, putting that in here, saying that, you're going to be doing that here and here. I don't think that that's going to change the liability issue.
Well, it's just my
Because it's
concern
already
about the modifier promptly. The other one just says upon receiving the request, then you
upon
should.
receipt of the request, yeah, which means immediately.
Well, I guess it seems to me that it hasn't been interpreted as being once you've gotten, you've been able to establish what that is, and my concern is by adding this modifying language over here that it's suggesting a different burden.
May I just speak for a minute?
Sure.
First of all, I'm involved, have been involved with the legislation committee here for some time. A couple points I'd like to, first of all, I want to thank you very, very much for coming, because you have something to offer. Unfortunately, organizations, including ours, ask for input, and I'm speaking particularly of the first issue you addressed. And nobody seems to pay much attention to us. So I really appreciate you taking time and visiting with us. What I guess I'd ask a couple things, just for my own benefit, is that do you think there's anything that should be done with that section? Let's set aside the public records request, but the section about the release of records, investigative reports, or do you think it should be left alone? And maybe more specifically, if you think it would benefit by some clarification, would you be willing to work with us trying to get to that?
Well, there are a number of proposed changes, and I can see the logic in if you're going to go in and ask for a change, you might as well do the set of changes. So some of them, ones that are more statutory construction, I don't know that I had an objection to the sort of the reframing of the portion of information about specific portions of electronic mail and telephone billing records. I don't know if that's more of a statutory construction issue. The one thing I did have a big concern about is removing the reference entirely generally from Chapter 22 to the confidentiality of privileged records or information specified in ADG.2. The reason that I have an objection to that is because that talks about confidential informants and things, ADG 2.2, and it's a separate confidentiality provision, but it appears to me that there's been an effort to try to call out, where there are specific confidentiality provisions, and that was added by the legislature when they created ADG.2, because I think they wanted to make sure that people knew that there's a special call out even beyond investigative records for everything that's confidential under ADG.2. So I did not object to removing it from this subsection, but I felt that there needed to be a recommendation to put it somewhere else if you were going to take it out of this subsection. So that's...
that could actually be a D down below. So that would still be part of that, but it wouldn't be part of that really crazy sentence that's...
It possibly could be a D below. I thought that the addition of the language to C was, I felt that actually was more confusing than clarifying, because there's very specific language in 5A that says if this is a crisis report, and a crisis report is defined as, and then it gives the information that is on a public safety form. So a crisis report is a very specific formatted document, and it contains information that's set forth in the statute. But it's very specific there. Crisis reports are not investigative reports. They should be kept confidential. However, they can be shared in a variety of contexts. So I think it's confusing to add a subsection under the investigative report section saying that crisis reports can be shared in this manner, because it sort of brings back into question, well, we already said they're not investigative reports, so why are we talking about it in an investigative report?
Well, I think that's the same reason, though, with 806.2, though. If we're going to take out 22.75A, we should probably take out 806.2, because they're a separate part of the law. But if you want to, make reference to those.
It's a little, so I'm afraid we're going to, this becomes, starts to get into a lawyer argument about statutory construction, but 5A comes right after this subsection, whereas ADG is in a whole nother section, so you might not know about ADG, but 5A follows immediately. This 5 is right here, and then 5A is right below it with crisis intervention reports. And I think the reason it was put in there is because people might think that a crisis intervention report is an investigative report, and they wanted to make sure that it was clear, like, hey, in case you're looking at investigative reports, crisis intervention reports are not investigative reports, but here's the special rules about them. Margaret and I had a discussion about, well, maybe they should have not called it 5A, because that's a little bit confusing, because it's sort of, and I agree that maybe it is confusing, a little bit confusing, but I think it gets even more confusing if you add something about the crisis reports back in the investigative report section. That's my opinion about that. And so, you asked me, if there's anything that some of these things are kind of fixes for, are really, I do write some ordinances. I'm not a professional legislation writer, but I do this kind of drafting. So, as a part of what I do. So those are some discussions about, if we wanted to say these things, what's the best way to put them in there?
See, I wasn't looking for the resolution this afternoon.
Okay.
I really wasn't, because we've been here since 1 o'clock.
Okay, fair enough.
And you had a long drive, and I understand it, but I want to underscore how much I personally appreciate your participation here today. It's very important, I think, to possibly move this ahead. But what I was thinking, we have a legislative committee, and that the question I guess I have is, will you really need to work with Margaret and or the committee to craft language that might get everybody where they want to go? Now, I understand that may be a place we can't all get to. But this is the kind of, I mentioned to Margaret, she told me before the meeting that you would contact me and you were going to be here. I was frankly, I was excited about that because nobody else has been willing to talk to us about this. It's on your side of the fence. It's all, just don't do that. You know?
Yeah.
And we have, I think, an obligation under the statute to pursue what we perceive to be improvements to the statute. Anyway, but that was what I was kind of driving at. And I know you're busy and you got a lot to do, but we might all be better off if we can kind of dialogue this thing through.
Well, what I would say is that I am certainly happy to be available and I'll be responsive to reviewing additional drafts. I've given some thought about how I would want to read this read, and frankly, I would probably lean towards a recommended, I have a phrase that I use in my work, which is when you put a jerry rig on a jerry rig, you wind up with a really funny looking animal. And I'm afraid this statute has had too many things attached to it, and then trying to further define, articulate this immediate facts and circumstance. I am inclined to maybe suggest sort of overhauling the whole section, because I feel like it's just kind of, each time everybody's had like something that they thought should be tacked onto it, and I think that's created problems.
That may be on the table as well.
Yeah, I wouldn't suggest I wouldn't suggest tweaking the language in this articulated list. This articulated list is problematic for all the different reasons that I listed there. So I don't have a quick fix, but this isn't, like I said, I wouldn't have driven over here if I didn't care about this. This is something that I feel very strongly about. I would be happy to review additional proposals and give feedback on that in a timely fashion without it having to circulate throughout the whole state and then get to me and then, but I can't also have duties as an attorney that I have an ethical duty to represent my client, and this board is not my client. So, to some extent, my input would be in representation of my client.
I understand that.
Yeah.
We all have day jobs.
I'm just saying that, I just have that's my perspective. I can't help, and you may have a different agenda for what you want this to look like than I do, but I would be happy to provide the input in terms of, what I really felt was that there were some unintended consequences that you guys might not have been aware of, not that you were, not so much that just, please just stop. I realize that you received a fair amount of that input, and so that's what I would be willing to do to assist.
That's fair.
It's practicing in, law enforcement and prosecutorial work. It's just, you have to take everything that comes in the door. So people who are doing that kind of work, on the state level, the federal level is different, but on the state level, you have to take everything that walks in the door. You are just constantly in a state of where you're just responding to what's happening in front of you. So there are very few people who have the time to sit down and look through these issues and game them out, long term, which I think why there's kind of crickets when you ask for the input, other than, we're nervous about that. We don't want that to happen. So, and that's just to explain sort of the phenomena. But I would be perfectly willing to be available to look at further drafts.
Well, thank you for your time.
Yeah.
We should talk about next steps for the stuff. Both up or down.
Right.
Yeah, just a question about 23.4. It seems like a lot of the complaints we get are from people who make a request for records, and then they don't hear anything. And then they file a complaint with us because they haven't heard anything. So isn't there something, an approximate date for the release doesn't seem to me to be unduly burdensome. What do you suggest? I mean,
my comment was that I was uncomfortable with that being paired with the requirement to do, to the modifier promptly, to add it to that list. I didn't go back and look, Margaret addressed the issue about the estimate of fees. I think that it's appropriate to, when you're able, once you've been able to develop an approximate, just from my standpoint, the ones that are tricky for me to tell them how soon I'm going to get it to them are the really big ones, and it takes me a while to figure out even what that answer is. So what we generally do is we send people a response that says we acknowledge, that we received it, the nature of your request incorporates a large number of documents, many of which may contain confidential information. It'll take a substantial amount of time for us to determine what we, what is involved with this as soon as we have an estimate of the cost and the amount of time it will take us to prepare the records. We'll provide you with that estimate, but it's our opinion, but it appears as if this is going to significantly exceed the $100 threshold. So that's how we handle it. I did not spend a lot of time gaming out where else in, here I might be better to, I don't think it's unreasonable for someone when they get a handle on the scope of it to provide an estimate of time. I just don't want the way this is drafted to just create more arguments about that, and that's what I'm worried about.
Most people, the bigger communities, the bigger government bodies, do exactly that. We received your request, here's your contact person, here's our estimated, here's what our fee schedule is, and we anticipate it'll be in this range, somewhere in this range, and based upon what we have to do to get those records, we anticipate having a response back to you within 2 weeks, or we'll let you know if there's any. So, and that would fit right into this. It would fit right into this. It's the ones where the record request is filed and nothing happens. There's no response. There's no acknowledgement. There's just nothing. And people are then like, well, what do I do now? And they're calling, or they're sending more emails, more record requests, and nobody knows exactly even who's supposed to be responding to this. So, that's, and then we get a complaint file because, they know how to get a hold of us. And then we have, sometimes it'll be 2 weeks before we can figure out or get anybody to respond back. We have lots of times complaints that we send out, and, a week later I'm, sending another email going, hello, and then, and then I make a phone call, and then I start calling other people to call and try to track down people. So just trying to address that in terms of, here's your responsibilities when you get a public record request. This government body, because that's who is the custodian, is the government body, and they appoint somebody or have somebody, but if they don't have anybody responsible, then they're the custodian, they're the ones that are supposed to respond to this. So here's direction on how you should respond. And you should do it promptly. And, I think that's easy for somebody on a factual basis to look at and say, okay, this was done within 5 working days. That, given the situation, it's a library board that only meets, only has somebody there once a week, that's promptly. There's nothing wrong with that. But, this gives the direction. Here's what you're supposed to do.
Well, and I would say record request comes in, comes to the custodian. If it's an email request, you ask your IT, how long will it take us to pull these records? You know that number, and then after that, based on your previous experience of reviewing emails, you can estimate how long it would take to review that. It just seems like that can be put together relatively promptly.
I would tell you that where it gets complicated is when you have the request that requests a large number of items that cover that could randomly contain various pieces of protected information. And so when a request comes from the county attorney's office, from the sheriff's office, the public health department, we know which ones are the hot button issues. And sometimes the board of supervisors, because they have closed sessions and things like that, but that's a little easier to identify. But they also have communications with their attorneys, so that's work. There's some work product privilege, some work product issues there in attorney-client communication. So, at any rate, when you get a broad request that triggers a number of those. So let's say I cover protected health information, attorney-client privilege, and maybe a couple other ones I haven't even thought of, and the request is broad enough, it just takes a little while to even get a handle on that. And those are the ones that are really problematic for me. Those are the ones that I know that even with my involvement, I can't give a response with any kind of accuracy other than to say, boy, your request is really big and it's going to be hard for us to deal with it. We'll get you more information. Which is what I routinely do when we get those. But that's not entirely contemplated by the language that you have here. And frankly, those are the ones that are more frequently going to lead to litigation. They're also ones that are requests that are probably precursors to, and I mean litigation against us, not just litigation about the turning them over, but litigation about the situation that they're requesting.
Well, but the more reason to avoid litigation is by having that communication, being able to respond with some estimates out there so that you at least have that individual know that I'm not waiting too long. And this is the reason we're waiting for those. Because,
Right.
again, just like what Margaret says,
I don't
what we
think
have
we're
is
going to get
trouble.
that resolved here. Maybe what the board needs to do, we've spent about an hour on this, decide whether we're going to go back to a legislative committee and involve her by phone, work on it more.
Yeah, I mean, that's, our timelines are such that whatever we want to put in the legislative packets for next year, I have to file no later than November 30th. That's my deadline by LSA. And it has to be approved by the board before I can do that. So we have today's meeting and we have November's meeting.
And we may
That's
not
it.
get 22/7 done.
Right.
We may not do anything with this.
Yeah.
It doesn't sound like we're going to get all the issues resolved.
So I'm at your service, whatever the board wants to do,
Well, I think the board needs to decide whether we want to send this back to the legislative committee and be in touch with the people further who filed comments. We appreciate the comments that are coming over here. I don't think we're ready after today's discussion to just...
No, I don't think there's any intent. But in the answer to your question, I think that makes sense. I mean, I don't know how anybody else feels. I think the whole committee's here, right? Barry's on the committee.
And Joe.
I'm not
Oh,
a
that's right,
legislator.
Joe, that's right. The sign of age.
Yeah, I would prefer,
No, I think it's just thought. I don't know. We can get on the phone and have a talk about it.
I think
What do you think, Margaret?
Two of the biggest county attorneys groups in the state came back with significant negative response to the proposal. I mean, I think it's apparent that it needs to be revisited. So that would be my thought as well. I can say, working in Boone County, we've dealt with this issue almost, even just recently. Video got published. We picked up a guy for a drug deal, and then he started spewing off names of other dealers on body cam. That video got sent, and then I posted on Facebook, and so now this guy, is potentially a hit list. It's just, there's just a ton of issues that go into releasing body cam footage without some sort of safeguards. As prosecutors, we have to release exculpatory evidence to the defense counsel, regardless. But that doesn't mean that there's an extreme public interest in providing any member of the public this information as well, right? If the case has to go to jury trial, the jurors aren't supposed to know about the case. So therein lies in another issue, right? I mean, look back to some of the high-profile cases that we've had in the past. They have to find jurors that know nothing about the case or know very little. So I think there's a ton of issues that I personally don't support, so I'd be on the board or on the side of moving it back to the committee.
Is that both? And I want to make sure that everything's really clear as to, there's two separate
I don't have it.
sections here, 22.4
Sure.
and 22.
That's for the 22.7 subsection 5. As to 22.4 subsection 3, I don't have as big of an issue with it. I mean, it seems to me like there's at least fair and legitimate questions to the language and how it could potentially be amended. I do think we have a duty to give individuals an opportunity to be heard by people and maybe make it easier for us to do our job as well. So, but I don't really have a strong opinion on 22.4, I guess, is where I'm at.
I think we're not going to get a resolution to 22.7 by November 30th. No way. But 22.4, I think it ought to, my suggestion would be you require an approximate date for a response to the request, not necessarily a date that you're going to release the documents, but within some reasonable period of time, the custodian ought to be able to say, well, okay, I've got a pretty good idea, this is going to take a while. So I can't give you an exact date, but I will tell you by such and such date that I'm working on it, and I will continue to update you. So I think we can resolve 22.4. We've talked about it some more.
I think so.
Because I think we need it. I think we need 22.4.
I think split it into at least two sentences. I agree with you.
Yeah, we could actually divide it into two sentences.
Well, do we need a motion or a vote to send at least the,
I don't know if you need a
22.75.
motion to send it back because they're a year and,
Just
I mean,
by
you can. if you want to.
consensus?
Yeah,
Yeah,
just,
I think so.
yeah.
well, the committee can take it up between
Yeah.
now and the meeting? Okay. Thank you so much for coming and sharing your
Well,
thoughts.
I really appreciate you guys listening to my comments. It is a really important issue.
Thank
Thank
you.
you.
Thank you very much.
And I will send around an email to the three of you tomorrow to see if we can come up with a time to have at least a phone meeting between now and then November meeting.
Maybe our first meeting, I might just be by phone. See if we can get something hammered out. They can come together.
In the interest of getting out of here pretty soon, can we speed through the rest of this office status reports? Do you want to leave that for our consideration? Is there anything that needs to be highlighted? I mean, we've got the hard
Other
copy.
than our hiring process. we're cool.
No,
In fact, I see
there's, it's just, that's just our stats, that's there for board information. They haven't forgotten about us in the last month.
Apparently not. Can we have a motion to adjourn?
So moved.
Second.
Dan and Barry? Everybody in favor, say aye. No, let's
Aye.
vote.
Aye.
Aye. I'm not even going to ask if anybody's opposed,
If anybody,
have 406.
if anybody's not,
because I'll
even
turn on them.
yourselves.
Thanks, everyone.
Thank you for working on that. That settlement.